लेके आ गया। हाँ, आ जाना चाहिए, कोर्ट बैठ जाए तो तुरंत। हाँ, जैसे होता है बताते हैं। जरूर जरूर जरूर। आप पहुंच गए? अच्छा अच्छा। ठीक। বুঝতে পেরেছি। কত হচ্ছে? আচ্ছা আচ্ছা, এটা তো 33-এর মধ্যে কত হচ্ছে? 21 কি আছে? আচ্ছা, তারপরে 68 অফ। আচ্ছা, ঠিক। দেখো, পুলিশ সম্রাট না। ফাইভ, টাকা ফাইভ। তুমি একদম সামনে দাঁড়িয়ে সন্দীপ, কোথায় দেখছি তো মামলার মধ্যে আছে। বলার মানে নেই বলতো। ও, তাই বলো। আমার সঙ্গে একটা সে সিএটি ওরা দেবে। আমি তো আমাদের একসঙ্গে পাঠাতে দিচ্ছি, আমাদের client হবে আপনাকে।
Lordships kind leave to file an appeal without the certified.
When was the order passed?
21st August 2025. We had applied with leave of the court on 3rd September 2025.
I have your lordship leave to file an appeal without certified copy. Order was passed on 16th September. That is on last. Much of
May be allowed to mention a matter in the appellate side. Your Lordship, the matter was wrongly listed before Justice Somen Sen's bench. It was thereafter subsequently released on 16th of September. It's appeal from an ad interim order. I'm only humbly praying it to be included in the list that is to come up on Tuesday. Lordship, appellate side. Grateful.
My lord, may I be permitted to pray for leave, my lord, for filing an appeal without certified copy of Siliguri Commercial Division, my lord. Two matters, my lord, where we have obtained true copy, my lord.
When was the order passed?
My lord, one is passed on 30th of August, my lord, and one is passed on 11th of August, my lord. I'm grateful, my
Lordship, may I be permitted to mention in the appellate side mention?
Is there no circuit at this point?
lord. No, my lord, there is no circuit, my lord.
Lordship, may I permitted to mention appellate side mentioning? I am praying for inclusion of the list. Lordship, all orders has complied. Paperwork has been already filed. But I am praying for inclusion of the list, Lordship.
After the vacation. Immediately after vacation.
Gratefully.
It was CAB matter. I come back after some time. No. I thought, my lord, your lordships were, my lord. No. We were discussing nothing about this matter. No, not about this matter. Yeah. I know. Yeah. About some other matter. No, that's fixed at 12 o'clock. The matter. Oh, yes. Okay.
You take priority.
No, ওটা 12টার সময়।
দিয়ে গেছে ওইখানটা।
Order is dated 26th of August.
Lordship.
Just allow us to go through the order once.
Lordship. না ওই 12টার মামলাটার জন্য দেখছিলাম আমরা আসছে শুধু
I'm not good.
Is that order 39 petition?
Kindly come to my lord, the page 395, possibly the last volume.
So
লেনটা যদি চায় 340 395 ঠিকই বলে
The petitions, volume 3.
starts off from 375 if I'm not mistaken 375 আর prayer হচ্ছে 400 370
375 it starts. The
That's-
prayer is at page 400. Sorry. করতে পারছি।
Mr. Sen, the prayer that they had made before the learned trial court, had that been granted, how would you be affected? That prayer.
Not so far as the CAB is concerned,
Yes.
but I'm not representing the other faction of or the other group which is fighting amongst
No,
each other.
only CAB is the
I'm not-
respondent here.
Lord, that is the unfortunate part. Lord, we have been made a party and the only party, and it's a faction-ridden club. There are two groups fighting over control of the
Therefore,
club.
this prayer couldn't have affected you.
No, this would have affected me to the extent that, Lord, under Rule 20 of my rules, I am supposed to maintain a register of members. And all communications by the CAB, including communications by the electoral officer, is to be done by the clubs at the offices addresses as maintained in the registrar. Now, Lord, this Monal Club was the club which has changed its address from place to place. It was initially an unregistered club. Now, Lord, at one point of time, Monal Club became registered under the West Bengal Societies Registration Act with its address at 57 Bagbaja Street. From then onwards till now, its registered address remains at 57 Bagbaja Street. Now, Lord, what had happened was that sometime in 2021, a suit was filed in the city civil court and an ex parte ad interim order was passed restraining us from giving permission to anybody else except from a group which had formed at 40 Goribari Lane, allowing players to play in our tournaments. Now, Lord, on the basis of this order, the electoral officer for that year and in the subsequent years have granted permission to the representative from 40 Goribari Lane to attend the meetings, take the grants, etc. Now, Lord, we discovered this mistake. But the electoral officer has recorded in his order. Electoral officer is a former member of the West Bengal Election Commission. It has nothing to do with CAB. Electoral officer records in his order that this order is only with regard to participation in this AGM, and he mentions the AGM. Now, Lord, unfortunately, on the basis of that, CAB has been recognizing the 40 Goribari Lane fraction as the actual representative of Monal Club till we discovered the mistake. CAB wrote a letter to the Registrar of Society saying that please let us know whether Monal Club is the club with has its registered office at 40 Goribari Lane. Registrar of Society writes back to us saying that no, the only Monal Club which is registered is the club at 57 Bagbaja Street. So, Lord, having realized our mistake, we immediately, Lord, rectified our records. Now, Lord, all disputes between clubs, between the CAB and its clubs, are to be decided by the Ombudsman in terms of Rule 70 of the rules. Now, Lord, this dispute was raised before the Ombudsman. Lord, the Ombudsman presently is my Lord Justice Jyotirmoy Bhattacharya. But the rules provide that the former Chief Justice has to be the Ombudsman. The two clubs, the club which says it's from 40 Goribari Lane, the club which says it's from 57 Bagbaja Street, CAB were all heard. And a detailed order has been passed by the Honorable Ombudsman holding that CAB's stand that it recognizes and it is entitled to recognize the club as at 57 Bagbaja Street has been upheld. There is no challenge to this order. There is no challenge to this order passed by the Ombudsman.
Is there a provision for appeal against the ombudsman's order?
No, there is no provision for appeal. But what has been happening is several orders have been passed by the Ombudsman with regard to different clubs. Either they're challenged by way of a civil suit, or sometimes we found that there are challenges by way of writ petitions when it involves a public interest like tickets, etc. But with regard to interstate clubs, what we have found is that suits are filed and then the orders of the Ombudsman are challenged. But this order of the Ombudsman, which is part of the application which has been filed, has not been challenged at all. The order of the Ombudsman is of 30th August 2025, recognizing that CAB has been right in recognizing Monal Club as at 57 Bagbar Street as the authorized affiliated unit of CAB. Lord, on that basis, now, Lord, what has happened, Lord, further, Lord, on that basis, Lord, thereafter, Lord, the elections of CAB were declared. And Lord, after the notification was issued, the electoral officer took over. And Lord, in terms of the notification of the electoral officers, it's essentially a caretaker committee now functioning without any authority to even hold an apex council meeting. The electoral officer has, not in my respectful submission, correctly, in terms of the orders which have been passed and his records, issued notice for the form to 57 Bagbar Street. Now, in the annual general meeting, each club is required to nominate a representative who is to attend and who may also stand for elections. Now, in this year, the electoral rolls are out. Only one set of candidates have stood, and there is no election because there is no competition for any of the posts. So the only issue now is who is authorized to represent Monal Club as a member at the annual general meeting, and essentially get a present and get dinner. Otherwise, there is really no contest at the annual general meeting. It's only a right of representation at the annual general meeting. Electoral officer has acted on the basis of the register of members maintained by the CAB and the Ombudsman's order, which is not yet challenged.
Yes, Mr. Mitru.
Lord, this is just the overview of the matter. Lord, we have recognized the 57 Bagbar Street unit as the correct Monal Club and issued them a notice. They have filed their.
Where have you annexed the ombudsman order?
Lord, one other aspect. Lord, one other aspect before.
Yes, maybe.
One other aspect before Mr. Mitru takes over, Lord. Now, Lord, on this basis, draft names of representatives have been issued by the electoral officer. It has been pasted on the boards and posted on the website. Lord, date was fixed for hearing objections in connection with this draft list of representatives. Now, Lord, Gauriwari Lane Monal Club has filed an objection before the electoral officer saying that they ought to have been allowed to represent and not the 57 Bagbar Street. Now, Lord, that hearing has taken place, I understand, yesterday, but I'm not very sure because as per the notification schedule, the hearing was yesterday. Now, Lord, what has happened at the hearing, I do not know. Electoral officer is the final arbiter as to who is to represent the club at the AGM.
Correct. Yes.
Number one, my lord, the order of the ombudsman is a subsequent order after filing of this.
Yes.
Number one. Number two, I can show your lordships the rules which has not been shown to your lordships. Ombudsman has got nothing to do with, my lord, a dispute between the members inter se of a club. It can decide, my lord, dispute between two clubs, A club and CAB, but it has no jurisdiction. As per the rules of CAB, it has no jurisdiction to decide any dispute between the members of the club.
Between the members and the club?
No,
Nothing.
That also not.
no.
No.
Number three, they admit that the registered office of the club, my lord, shifted, my lord, from time to time to different places. Basically, on the basis of, my lord, the idea was the office bearers, residents, some office bearer, either the president or secretary or treasurer, someone, his residence was used as the registered office. Now, the last secretary at whose this the Bagbajar Street address was the address of the last secretary. Now, my lord, he died during COVID. So immediately after COVID, my lord, there was a meeting of the general body of, my lord, the club. The club decided to, or the general body of the members of the club, they decided to shift the office to the Gauribadi Lane, which is, my lord, the address of the present secretary who was elected as the secretary or treasurer, whatever it is, treasurer. Now it was, I shall show you, your lordship, my lord, or may I show? Decision was taken, my lord. Kindly come to, my lord, page 174, second volume.
Before we go to the decision, take instruction. Did your clients participate in yesterday's meeting before the electoral officer?
Yes.
Did your clients participate in the hearing before the ombudsman?
Yes.
Why, if the ombudsman has no jurisdiction?
But this point was taken there. I understand.
No, you were not there, Mr. Mitra. Order will speak.
Order will speak.
Order will speak. Does the order say so that this
No, it does.
objection? Then we take it that you did not take the objection. We have to go by the order. So therefore,
Oh, it was there in the written objection before the ombudsman on papers.
written objection, several things are there. Often you know that best. So this, anyway, now you make your submission.
Yes.
And what was yesterday's decision?
No decision.
Nothing communicated to us. Nothing communicated.
Hmm.
Now kindly come to page 174, my lord. At the top, lordship should find minutes of the special general meeting of the club held on 30th January 2021 at 5 p.m. etc. Kindly turn the page. Agenda number 1 to fill up the vacancies of the following office bearers of the governing body of Monal Club, Honorary General Secretary, Honorary Treasurer. Then kindly come to, my lord, the penultimate paragraph under that heading. The President informed that since there is only one nomination each received for the posts of Honorary General Secretary and the Treasurer, Mr. So-and-so and Mr. So-and-so, therefore are the unanimously elected as the Honorary General Secretary and Honorary Treasurer respectively. Then kindly turn the page. Agenda number 3, to apprise the members of change of address, phone number, email ID of Monal Club as approved in the emergent meeting of the governing body. President apprised the members of the change of address, phone number, email of the Monal Club as approved in the emergent meeting. New address of the club is 40 Gauribadi Lane. Kindly turn the page. Page 177. TAB is communicated of this.
Yes.
CAB is communicated of these decisions. Now, my lord, even after that, my lord, after 1st of February, some, my lord, people, my lord, some persons, supposedly the other faction, my lord, they were trying to, my lord, represent themselves as a club. So, my lord, a suit was filed. And in that, my lord, an interim order was passed on 9th of February 2021, restraining them, my lord, from representing the
Who filed the suit?
we. This order was passed on 9th of February.
Shouldn't you have added those persons in this suit also?
My grievance is CAB, my lord. CAB from
Correct.
From 2021 till 2025 January, my lord, they never disputed my right. They never said in writing that you are not the person. Now today, suddenly, my lord, they wake up for obvious reasons and they say, no, you are not there. My lord, I will show your lordship, all the documents are annexed, my lord, all the elections from 2021. I get the notice, I participate. Other things, my lord, money receipt, yes, I do it. And today, suddenly, in August 2025, they said, no, you are nobody. I only recognize them. Now, kindly come to the plaint ones or the petition, which was the suit filed, my lord, in 2021. The plaint also, my lord, kindly come to page 178, the next document. (178) Lordship should find, my lord, Monal Club and Devobroto Pal, who was the secretary appointed in the meeting. Then, my lord, the suit against, my lord, the persons who were claiming to be, my lord, the... Yes, kindly come to the prayers. Page 194.
Yes.
My lord, kindly once come to page 193. Page 193, my lord, paragraph 52, why this suit was required to be filed, that would appear, my lord, about 6 lines from the bottom of that page, my lord, or 7 lines. The cause of action of the instant suit first arose on 26 January 2021 when the plaintiff for the first time came to know about the false representations on the part of the defendants number so-and-so purportedly and wrongfully claiming themselves to be the members of the elected governing body of the plaintiff number 1 society, and subsequently on such and such date when it transpired from the records of the defendant number 14 that the defendant number 1 to 13 by false and fabrication
fabricated manufactured document.
fabricated manufactured documents before the defendant number 14. Now kindly look into who the defendant number 14 was or is. The suit is pending. Page 180. Sorry.
14, huh?
14 and 15, yes.
14 is pro forma defendant.
Yes.
Yes, and
Yes.
15 is CAB.
15 is CAB. So, my lord, CAB was or is aware of the suit. In this suit, an order was passed, my lord, on
215.
9th of February 2021. Kindly come to page 215. Kindly come to page 216. Now, this order was subsequently confirmed on contested hearing, my lord, in 2024. That is the next
The
document.
civil revision is pending in the High Court.
Civil revision, there is no order. It's pending.
228 misappeal.
If
Yes.
it's right.
228.
217, it starts the appeal court order,
220.
goes up.
220. Appeal court.
Sorry, appeal court. Sorry.
হাইকোর্টে কি অর্ডার হয়েছিল সেটা দেয়নি ওদের সেটা তো দেখানো কিছু হাইকোর্টে রিফিউজ করেছিল if my memory was correct এর against রিভিশন হয়েছিল ওরা স্টে রিফিউজ করেছিল
Revision pending.
হ্যাঁ রিভিশনটা পেন্ডিং আছে nobody moved anything if once this is confirmed then how can they have two orders separately
How could Jyotirmoy Bhattacharya
could not have he's not
In the Societies Registration Act,
Yes.
isn't there a requirement that if the registered society changes its address,
Yes.
the register of societies has to be informed.
Yes, yes.
Sections 8 and 9.
Has been done.
It was done.
It was done.
Yes.
No. The change has to be effected by the
That's
registrar,
different
only
question,
thereafter it
Malad,
takes
yes.
effect.
I
Only
cannot say.
intimation was given, no form
Can't
was
go
filed.
beyond the civil court's order.
May I, Malad? May I? Now, it was.
See, that's one more thing. Does any of these different numbers 1 to 13 in your previous suit,
Yes.
is any of them trying to represent the club before CAB today? But then why will this order of injunction not bind you also?
Lord, so if your lordship has a look at the order of injunction,
At page 216.
yes, Lord. Now, Lord, what the stand is, Lord, that the registered society is a society at 57 Bagbara Street. There has been no change. Of only intimation given to the register of societies does not result in change. Now, Lord, this is another society which has been created at 40 Goribari Lane, claiming itself to be Monal Club. The original Monal Club continues at 57 Bagbara Street. Now, defend numbers 1 to 13 are not claiming themselves to be members of the plaintiff number 1. Plaintiff number 1 is a new club which has formed itself at 40 Goribari Lane, which is not the, it's like Monban Club being formed at Raja Bashantara Road.
Who is, so far as CAB is concerned,
Lord.
who is representing Mohun Bagan Club of 57 Bagbaja Street?
At the AGM, which has now been
Who is representing
Mohanlal Club.
57?
Mohanlal Club.
Mohanlal Club.
Bagan.
Mohanlal. Who?
Mohanlal Club
Of 57
Yes,
Bagbaja.
Lord. The name of the representative who is going to be attending as per the
Yes,
list
yes.
submitted by them is one Shoikot Goswami.
Shoikot Goswami, isn't he a defendant? Defendant number 1. Restrained. Restrained. How can he?
Now, Lord,
And how can you? You are also a party in this suit.
yes, Lord. Now, Lord, if your lordship has a look at the frame of the suit and the prayers, the restraint is from the defend numbers 1 to 13 from representing themselves to be members of the plaintiff number 1. From representing themselves to be members of the plaintiff number 1. Now, Lord, please see which is the plaintiff number 1. The plaintiff number 1 is an entity at 40 Goribari Lane, not the entity at 57 Bagbar Street, which was the original entity. This is a new mushroom which has come up at 40 Goribari Lane, claiming to be the original, by proxy, the original club. These people are not claiming themselves as members of the 40 Goribari Lane unit. Now, this is a
Is
stand
the
of CAB.
register of societies here?
They must have not. There's a notice.
Not
Your
a-
lordship has a look at.
Register of societies is not a party here, of course.
Lord, if your lordship has a look at the application which has been filed, Lord, the application which has been filed, I think
We wanted to know, does this address 40 Goribari
Lord, that
Street?
is what we inquired from the registrar. That is a specific question which we put to the registrar, and the registrar wrote back to us. The lordship will find that at page 19 of the can 2. And this was placed before the ombudsman.
Page 19.
19, Lord. প্রশ্নটা কোথায় প্রশ্নটা কোথায়
নেই নেই
প্রশ্নটা ছিল
নেই বলা আছে নেই
Now, Lord, this was placed before the ombudsman. I don't find the question having been annexed by the applicant, but the query which was made by the CAB and recognized and recorded by the ombudsman.
স্টেপ নেওয়াটা অন্য কথা
Lord, please take the certificate, Lord, which is at page
No,
59 of the.
let him finish.
I'm so sorry. I'm sorry.
We interrupted.
No, I'm sorry.
Now, my lord, this was the order which was confirmed, my lord, in 2024. The other group, the other faction, they filed an appeal. The appeal was dismissed on contest. From that, civil revision petition was filed. I understand. I was not there. I understand, my lord. No stay was granted. possibly prayer was made or whatever it is, as on date, there is no stay. So the order of the Shelda court as confirmed by my lord the district judge is continuing as on date. Now, what happened after 2021 when the order was passed? Lordship will kindly come to my lord page 197.
Yes.
Kindly come to page 197. A list published by the Office of the Electoral Officer of CAB. Final list of eligible representative nominated by the affiliated members of CAB as on 28 September 2021 for attending the annual general meeting of 29 September. Kindly turn the
Kajol
page.
Kumar De.
Sorry, my lord.
Yes.
Who is
Kajol
Kajol Kumar De?
Yes.
He's your group.
Treasurer. My treasurer. Whose name is there, my lord, in the meeting.
হতে পারে।
Now, kindly, along with this, kindly come to page 306. Office of the Electoral Officer, so and so. Order by the Electoral Officer of CAB in regard to the petition of Sri Amod Tigga, who is now seeking to represent the club by making the application for intervention. There is scan 2, my lord, from which Mr. Shen was pleased to show that is, my lord, the application made by Amol Tigga as the Assistant General Secretary of the club for intervention. Now,
He's your group or the other?
other group, theirs. Of Sri Amol Tigga representing himself as the Honorary Assistant General Secretary, Monal Club, such and such, on 23rd September. Kindly come to the third paragraph. A representation and nomination form in Annexure A was received from Monal Club under the signature of its Honorary Secretary, Sri Devobroto Pal, and the chairman of the meeting held in the club, Sri Revati Kumar Ganguly, nominating one Sri Kajol Kumar De as its representative. In terms of the schedule fixed by me for submission of representation and or objection, if any, to the published draft of representative of eligible affiliated members and former international cricketers qualified to participate in the AGM and entitled to vote in connection with the resolution to be taken at the AGM. One Sri Amol Tigga, said to be the Honorary Assistant General Secretary of Mohanlal Club, submitted a representation addressed to the Electoral Officer on 23rd September 2021, hereinafter referred to as the said petition, raising objection regarding the nomination of Kajol De as the authorized representative of Mohanlal Club in the annual general meeting of CAB on 29 September. In compliance with the principles of natural justice and to ensure that all interested parties are adequate, etc., then my lord, kindly turn the page on the appointed day, etc. Kindly come to page 308. Considering third paragraph. Considering all aspects of the matter, including the submission made and the documents submitted, I appreciate that there are acrimonious disputes in the matter of control and management of Monal Club. However, it is beyond the ambit and scope of the electoral officer to go into such matter. Furthermore, two civil suits are pending, one before the learned Shelda Court and the other before the learned City Civil Court at Calcutta. As electoral officer, I am conscious that I ought not to make any observation on the issue by which either side may be prejudiced in any proceeding. Taking into consideration and keeping the above aspect of the matter in mind, I would like to place on record my observations. Then, my lord, those are recorded. Kindly come to the page 309, the last paragraph. I am omitting, my lord, to cut short the matter. His observations. 309, the last paragraph. Now kindly come back to, my lord, the first volume, second volume which I was showing. Kindly come to, my lord, page 200. I showed 197, 198. Kindly come to page 200. This is the list of the next year. AGM on 31st October 2022. Kindly turn the page, serial number 75. No dispute. Now kindly come to page 203. 2023. Kindly turn the page, kindly come to serial number 76. Monal Club, Kajol Kumar De. Now kindly come to page 206, 2024. Kindly come to serial number 76, Kajol Kumar De. Along with this, my lord, kindly come to volume 3, page 312. Again, objection was raised for 2024. Come to, my lord, page 312, objection by the same person, Amod Tikka. Kindly turn the page, kindly come to 313, the penultimate paragraph. Yes. However, in terms of the existing documents, inclusive of the order passed by the learned judge, 10th bench, to the effect that the title suit does not in any manner restrain Kajol Kumar De from being representative of Monal Club, the ensuing AGM of CAB, and in continuity with the representation during the last 4 AGMs, I allow Kajol Kumar De. Well, this was the AGMs. Now, kindly come to, my lord, special general meeting, my lord, kindly come to page 209. My lord, this was special general meeting of CAB, held, my lord, in 2022, 26 October 2022. Kindly turn the page, kindly come to serial number 33. Kajol Kumar De, Monal Club. Now kindly turn the page, kindly come to page 212. Office of the Electoral Officer, etc. Final list of names of representatives nominated by affiliated members for attending the special general meeting on 2nd March 2025. This is why, my lord, I submitted before your lordships that, my lord, from 2021 till 2025, there was no dispute from the side of CAB. Now kindly turn the page. 213. 76, Monal Club, Kajol Kumar De. No, they did not stop, my lord, in the meetings. CAB did not stop only in the meetings, my lord. Kindly come to, my lord, in the same volume, kindly come to page 229. Lordships would find list of available players of Monal Club for registration for the season 2020-2021. Now kindly come to page 234. Kindly come to page 234 on the right hand side. Lordships would find the signature of Devobroto Pal, who is the secretary, honorary secretary of our group. Same thing is there, my lord, in the next page. That is for 2022-2023. I'm omitting that. Now, my lord, kindly come to page 239. Lordships would be pleased to come to page 239. Kindly come to page 239. Player's identity card is being issued by the CAB. Kindly see who has signed on behalf of the club. This is 2021.
Yes.
2021. I can show all. I am omitting for the time being. Kindly come to page 289, which is for the year 2024-25. For all the years, it's there. Similar ID cards. Kindly come to page 289.
Here the suit is by you, and the other suit.
My lord, the suit was by me. Then, my lord, a second suit was filed by them in the City Civil Court.
City Civil Court. And did they obtain any order there?
There was an order which was of no effect, my lord. It did not restrain us from, my lord, doing anything.
That's the finding in the electoral
Correct.
officers.
That is also, my lord, would appear from the electoral officer's recording.
না না সে তো ওরাই সিএবি তো বলেছে ওটা
And I'm sorry, it's not কি করা যাবে। Register of forms was intimated.
দেখিয়ে দিতে বলছে তোমার
কটা রেকর্ড নয় কি করা
ওরা
যাবে?
স্যার অ্যাকনলেজ
ওরা acknowledge করে চিঠি দিয়েছে
ও
এই চিঠি
341
সিএবি মোহনলাল 42
তুমি তুই এইটা
Kindly come
341.
to page 341 once. My lord, volume 3.
no part ওই অর্ডারটা
Yes.
December 2024, my lord, CAB writing letter to me. 40 Gauribadi Lane, we are in receipt of your letter. We regret to inform you that we are not in a position to reschedule the match between Monal Club and Calcutta Farsi Club, scheduled to be held on such and such. আচ্ছা টাকা পেয়েছিলাম ওই রিসিট গুলো কোথায়?
এইটা ছিল হচ্ছে তোমার যেটা অর্ডার 7/11 টা শিয়ালদা কোর্টে রিজেক্ট হলো অর্ডার 7/11 টা রিজেক্ট হলো
Electoral officer will
চ্যালেঞ্জিং
Yes.
Now, my lord, টাকার রিসিট গুলো কোথায় আছে বলো?
Where is the order of the ombudsman?
আমাদের কাছে
It's not there, my lord. It's the appeal was, my lord. The impugned order was before the order of the ombudsman, and my lord,
the appeal also
appeal also. But they have annexed, my lord, in
the other one
can 2.
মানে সৌরভ দ্বারা ফাইল করেছে
মেমোটা কোথায়?
এইটা
বার করো। হ্যাঁ, মেমোটা দাও, মেমোটা
টাকা
দাও।
রিসিট করে বার করবেন
এইখানে বললে তো হবে না বাবা, বার করো।
আচ্ছা আচ্ছা ঠিক আছে পেজ 25
হ্যাঁ, বলছি,
হচ্ছে
বলছি।
20 থেকে আরম্ভ 25 হচ্ছে
Mr. Mitro, the appeal was filed much after the ombudsman's order,
September
9th of September.
No, I'm sorry, my lord. Sorry, my lord, for making an incorrect statement. But I understand, my lord, the order was received by us subsequently.
much later.
Achha, where is that order? That is annexed to Can 2.
Can 2,
কোথায় Can 2 খুঁজে পাবো ভাই?
page 21.
Second September is the letter communicating.
Yes, yes.
Hmm.
Hmm. 23 bottom. Check. Check গুলো 330 তে আছে। হ্যাঁ 330 তে। Check দেখুন। না, এই যে চেক নাম্বার গুলো দেওয়া রয়েছে এখানে। তারপরে check।
But kindly come to, sorry, your lordships are reading it.
করা উচিত ছিল সবটা প্রথম দিন তোকে বলেছিলাম। কেন করে এগুলো আমি তো সেখানেই তো আসবে, ওটাই তো আসবে। এ দেখো রিজনিংটা দেখো,
আসছি 23 টা দেখো।
24 এটা কাছাকাছি কি করে দিল এটা আমি বুঝতে পারছি। রিজনিংটা হচ্ছে যে রেজিস্ট্রার অফ সোসাইটিস তো লিখেছিল সিএ, ওরা তো বলতে পারে which is wrong, actually wrong.
কমরেড বুঝিয়েছে।
না 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 চলে এলাম।
Mr. Mitro, kindly show us the rules regarding ombudsman.
70
কপি দাও।
We have a matter fixed at 12 o'clock. That is why we are trying to.
Yes, ma'am.
173 173 হ্যাঁ না 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 কোথায় রয়েছে এটা এতে?
Yes, we have them.
No, no, I'll give it
Yes.
separately. Page
Rule,
I will tell you, Lordship. 7-0 possibly, kindly, my lord.
last. কোথায় গেল রে? জানি না। আচ্ছা আচ্ছা এই
Page internal page
126
the rule 70.
এই তো নাও না তুমি এটা নাও না
Yes. Members,
association
association are members.
and its members. Association its members. Not
একেবারে।
the group just say it's about
Yes. And
inherently lacking the respect. There was no dispute with CB at all.
yes. Rule 70.
yes, we've seen.
No.
Need not place, we have gone through it.
Yes. Now, my lord, so far as I shall show your lordships two further documents and then, my lord, I will stop. My lord, I know because the time limit. Now, kindly come to, my lord, the Ombudsman order, page 23 once. I'm sorry, page 23 of Can 2,
Yes.
internal page 3 of the order.
Yes.
The penultimate paragraph. Suffice it to mention herein, Justice Raikot. Suffice it to mention herein that the only interim order which still binds the parties is the interim order which was passed by the learned civil judge junior division. As such, the details of the other litigations need not be elaborated herein. Only important aspect which is required to be taken note of is that there is no injunction restraining CAB from taking any step concerning such dispute between those two rival groups or persons. CAB is not sitting in appeal with greatest of respect. CAB is a party to that suit. CAB knows that, yes, there is no order against CAB. But it means CAB is today setting aside the order passed by the Shelda court, affirmed by the appeal court, and, my lord, not interfered with by this honorable court. Maybe CAB is the Supreme Court. I really do not know.
We can't go against the civil court order.
Now, kindly turn the page.
The complaint একবার দেখিয়ে দেবে না? What was the adjudicated?
সময় হবে না।
দেখিয়ে দাও না, দিত।
Now, kindly come to the next paragraph.
This is the
Page
adjudicated.
23. Since there was a complaint by the persons claiming to be the members of Monal Club who were restrained by the Shelda court order, having its registered office at 57C Bagbajar Street, that they are not getting the grant from CAB held an independent inquiry to ascertain which Monal Club is actually affiliated with CAB. CAB wrote a letter on 16 June 2025 to the Registrar of Farms, requesting him to provide CAB the registration number of Monal Club and also to confirm whether 40 Gaudibadi Lane is the registered address of Monal Club as per the entry made in the register of forms. CAB makes inquiry, does not call upon me, proceeds of its own. Then, my lord, it goes on the basis of the address, completely ignoring the, my lord, wish of, my lord, the members of the club, which was reflected in the 2021 and the general meeting of the club. Those meetings, those minutes are not under challenge. CAB has accepted that from 2021 till 2025 March. With greatest of respect, my lord, today, my lord, CAB cannot turn around and say before the court, sorry, I made a mistake. No, that was the submission. It was a mistake. Now, only one further document, my lord. Kindly come to page 330. Volume 3. My lord, letter from my lord Devobroto Paul as the secretary about the checks. The checks are received by us. Kindly come to page 332. I received this letter. Annexure T, 332, 333, all.
Suddenly, ইলেকশনের আগে অন্য কাউকে দরকার
As late as 5th December 2020.
341
Yes, 341, it goes up to it.
5th December 2020.
আমাদের প্লেয়াররা খেলছে অ্যাডমিটেড ফ্যাক্ট এই যে প্লেয়ারটা দেখালো সিবি ক্রিকেট
And my lord, the players sent by us are still playing. My lord, in view of this, my lord, after the learned court below, after holding that, my lord, I have made out a prima facie case to go to trial, my lord, ought not to have refused the order of injunction and kept it sometimes in, my lord, October or November, my lord, when, my lord, everything would be over. Today, my lord, CAB is only interested, obviously, for obvious reason.
ইলেকশন ইজ কামিং
Those are my responses.
22nd
Yes, the election is on 22nd.
No, showing the election হচ্ছে না. There's no contest.
Oh, election হচ্ছে না, there is no contest.
No, AGM তো হবে. Lord, if your lordship, very quickly, my lord, may I just show your lordship a few documents? If your lordship is pleased to take, my lord, the volume 1 and not the registration which was affected. Volume 1, page 58.
এটা কিসের?
After volume 1.
Okay, দেখে নিন। What is this?
Look, this is the registration certificate of the Lord, the memorandum of association and the rules of Monal Club, which was registered with the Register of Societies
In 2021,
in 2011.
2011. It is not disputed by them, Mr. Sen, that the registered office was 57.
Is
Their
57
case is
Bhagwat Street.
in 21 at a special general meeting or whatever it is, decision was taken to shift the office to 40 Gaudibadi.
Now, Lord, decision having been taken, Lord, sections 8 and 9 of the West Bengal Societies Registration Act lay down a procedure to be followed. Lord, if your lordship has a look at the West Bengal Societies Registration Act,
না আসলে গেছে
yes. Lord, please have a look at section 8. It talks of previous permission of the registrar in writing and the votes of 3/4 of its members. Section 8, subsection 1.
Of course.
Then the satisfaction of the registrar.
Correct. Correct. Uh, yes.
Lord, section 8, subsection 1, subsection 2 talks of the procedure. It requires the previous permission of the registrar, vote of 3/4 of its members. Subsection 2 requires the registrar to satisfy himself that the change in the memorandum will not make the society not ineligible for registration. 9 subsection 4 says that the alteration will have effect from the date on which intimation referred to in subsection 2 is received by the society. Except for giving a letter intimating its purported change, nothing has been done. But if your lordship has a look at the rules, the West Bengal Society's Registration Act rules, there's a form in which this is to be filed.
Where?
Rule 9. If it is after the statute, Lord, usually these barracks
Yes,
have the
rule 9.
Lord, rule 9. Statutory form is to be filed. Lord, just giving a letter saying that we have done
This form was filed.
Nothing. This issue was raised. Nothing was done.
Factual question.
Yes, yes.
Form was filed.
Form file
No, form. Show it that. Lordship, just show the form filed now.
And previous consent of the permission of the registrar was taken.
Miller, we had given them the intimation with leave of my senior Miller,
Yes, exactly.
and with respect to whether Miller it was filed or not,
Of course. It is
whether it was filed or not, Miller, is an instruction that we have to take, because we didn't know, Miller, that CAB would be making this.
No, same submissions can be made by anybody.
Simply, we want to know whether Section 8 of the 1961 Act and Section Rule 9 of the rules were followed.
Well, intimation was there, definitely.
Intimation was given, my lord. It has the seal of the registrar.
Registrar, there is no problem
Now,
at all.
form rule 9, my lord.
We don't have it right now.
Form 4.
কিছু হয়নি। ও,
তুমি
legal
যদি
discuss
এখন
করেছিল।
registrar of
না, না,
society হয়ে যাও, এখন
এটা
তো
প্রশ্নগুলো জিজ্ঞেস করেছিল। কিচ্ছু হয়নি।
না হোক।
Now, so far as form 4 is concerned, my lord, I don't have.
Penal consequences.
Yes.
Now, Lord, may I show your lordship the query which was given by CAB having regard to the dispute? Because the query has not been annexed as part of your lordship's record. The answer given by the Register of Societies is given. The query which was issued is not there. But it is part of the
Do you have the plaint of the Sialda court on record?
Yes.
Where is it?
170 whether.
I'll give you a
If I'm not mistaken, it's 170.
171.
If I'm not mistaken, subject to correction.
there is a misrepresentation by
170.
Buribaril claiming itself to be a registered society. And this was pointed out before the Ombudsman. And the
Not
Ombudsman
171.
back in page 24.
178.
Yes, all right, Mr. Sen.
Lord, if your lordship has a look at the order of the Ombudsman,
Yes.
Lord, which starts at page 21.
Yes.
Lord, if your lordship please comes to page 24. It is an undisputed fact that Monal Club is a registered club, etc. Lord, please come 3-4 lines below that. The said registered address of the club remains unaltered as per the records of the Register of Firms, Societies, Non-Trading Corporations, Government of West Bengal till now. No official document could be produced by the group of persons claiming to be members of Monal Club having its address at 40
We have
Bodiwali Lane.
noted that. We have noted that.
Now, Lord, please not have a look at the query, Lord, because of the dispute as to who should be the club which we should recognize in terms of Rule 70. This is the
Yes.
query we had given.
Very well.
This
And
is part of the records.
we will see. Also take instruction, please.
Yes,
Yes, at yesterday's meeting before the electoral officer,
yes, Lord.
what transpired?
Lord, as per Lord, the schedule, notification as per the schedule, I understand the orders are to be issued today. There's a electoral notification has been issued. As I find from notification that examination of objections started from 18 September and publication of final electoral roll 19th after 6 p.m. So the
Today after
decisions
6
will be issued during the course of the day and the final electoral roll will be issued in the evening. Because I understand
What we propose to
What
do,
I
we'll
understand
keep
is that
this matter as for orders on Monday. Tuesday is the election.
no, election is on Sunday, 22nd. AGM is on 22nd.
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 ওনার সাথে 22 Monday. Monday at 6
Monday,
p.m.
sure. Oh, acha, Monday.
Yes. So Monday morning, we'll keep this as, get the instruction, the final electoral, whatever you call it.
Yes.
It will be ready by then.
Of course.
What else? What else, Mr. Chen?
Now, Lord, the query, Lord, which was given by the Lord, if your Lordship has a look at Lord,
Yes.
page, this is Lord, page 28 of the written submissions that CAB had filed before the electoral officer. Page 28. This is the question we had asked. This is to inform you that Monal Club is an affiliated unit of the Cricket Association Bengal. You are requested to kindly provide us the registration number of Monal Club. Please also confirm us whether following address is registered address in your esteemed department. And we gave the address with the unit with which we were communicating, giving them grants, allowing them to attend.
Suddenly, why did you ask for
Lord,
this?
because of the disputes which were raised by them. They had issued a letter to the Register of Societies and they had got a clarification, made it over to us, but we required to satisfy ourselves. No, this is on record.
Who wrote to the Register of Society?
The Register of Societies letter was written by the Bagbazar Street group.
They have not said in their application, my learned friend.
This was before the Ombudsman. This
I
came
do
up
not
before
know.
the
They have
Ombudsman.
come up with an
My learned
application.
friends juniors.
They have come up with an application. They do not say that.
This inquiry was made, and from this inquiry, it transpired
I'm sorry.
that 57 Bagbazar Street is the address. Now, Lord, one more minute, Lord. Lord, two orders of the electoral officer were shown to your Lordship. I'll just show the last paragraphs of these orders. If your Lordship has a look at page 306.
CB is not about
Page 306.
No.
Lord, this is the first order, which Mr. Mitro showed your Lordship. Yes. Lord, if your Lordship is pleased to have a look at, Lord, this order, and Lord, please come to, Lord, page 313. Page, Lord, 306, Lord, the order starts, Lord, please come to 310.
Yes.
Of course, the right of Kajol Kumar De to attend the AGM should not be construed to have any effect on the control and management of Monal Club or howsoever interfere with respect to the participation of the players of Monal Club in the cricket tournaments to be organized by Cricket Association of Bengal. This order is limited to my considered view as electoral officer that there is no impediment in Kajol Kumar De attending and participating in the AGM of CB on 29 September 2021 as representative of Monal Club. This order is not to be construed as permitting Kajol Kumar De to have any other right or to howsoever affect or prejudice the rights of the parties in the diverse legal proceedings. So the next order which was shown to your Lordship is at page 312. So I'll just take one more minute, Lord. 312. Lord, please come to Lord page 313. Lord, the middle paragraph. Lord, this is the second order which was shown.
Yes.
On perusal of the documents submitted before the undersigned by both the parties, along with the submissions made in course of hearing, I find that Kajol Kumar De representing Monal Club during the last 4 AGMs of the Cricket Association of Bengal, and there has been no change in circumstances since the last annual general meeting of the CAB. However, I do not find any reason why the concerned parties representing Monal Club did not initiate any steps to register their changed address of 40 Goribari Lane in all records, including the certificate of registration before the Register of Firms. I make it a point to get the records corrected by them before the next annual general meeting, and they also to produce an order from the competent authority in the matter of their representation as representative of affiliated member of Monal Club. And the last paragraph is a disclaimer. So, the electoral officer took note of the fact that they have been attending. It is not a disputed position of fact that we have been allowing them. Mistakenly, the mistake has been discovered But that cannot allow the illegality to be perpetuated for ad infinitum. We made a mistake. We've accepted the mistake. Now, Lord, the position is this, Lord, as the Ombudsman has recognized. There is no, Lord, appeal from the order of the Ombudsman or any other challenge. It's a, Lord, determination
There
of
does
fact.
not appear to be any provision for appeal, but
No,
it can be challenged otherwise.
in order for which
Suit or rate or whatever we do.
But, only one addition in my lord response. CAB is very active. Very. Now, the Ombudsman did not take into consideration the fact that the complaint was lodged by one Monish Sarkar who was restrained by the 2021 order.
And it's an honest in the eye of law.
And
Completely beyond
the
this
order, according to me, my lord, is non-est. No, my lord.
jurisdiction.
He had
it
no,
falls within Rule 70.
No, it doesn't.
Rule
I
71
have
it
shown
certainly
you.
falls.
Your
doesn't.
lordships have seen rules of it.
Very well. Hearing is concluded. Rekho?
No. I am objecting to his.
Not necessary, not necessary.
He has, my lord, I can show your lordship a person who has no
Not
ability
necessary.
to
Not
make the
necessary.
appeal.
We have heard learned counsel for the parties at length. Hearing is concluded. Paragraph lists the matter under the heading for orders inverted comma on কবে সোমবার Monday carries the এই Monday কিছু fixed আছে কিনা Monday
এগুলোই হয় মানডে এগুলোই জাজমেন্ট দেবেন তো আচ্ছা বিফোর এনিথিং এলস প্রেজেন্টেশনের উপরে শুধু
marked 12:30 p.m. Marked 12:30 p.m.
grateful to you.
or whatever it is worth reading. Hey. Mr. Sen, we are keeping this with us for the timing. We'll return it on Monday.
Really a storm in a teacup.
ওইটা থাকবে ফাইলে দিচ্ছি
I was only wondering that the electoral officer, poor gentleman, will be shivering now. Which way to go, knowing that your lordship has kept it on Monday.
bring the final electoral list on Monday. এই বইটা কি আমাদের ফাইলে দিয়ে দাও দুজনেরই ফাইলে
আরে
the matter. You're also in that matter.
I mean, item 4 also, my lord.
No, but 12
Yes,
o'clock
yes, my lord, 12
fixed
o'clock.
matter, and that will surely continue till 1:15 without any doubt.
At-
Then 2 o'clock
At
issue আছে
2, perhaps, my lord, we can.
and then we can take it up at 2 o'clock, but at 2 this bench is available only till 2:45.
We are, my lord, asking for a stay of, my lord, the order, my lord, which has been
No,
passed.
that's already well pointed.
We can start at 2 o'clock
Yes.
and then depending upon the convenience of the court.
We'll have to rise at 2:45
Yes.
because of different benches. We'll do that then.
Very well.
So you can go and relax now.
Lordship, in that case, may I make a prayer?
Who are you for?
I am in item number 3. The other day, they had sought accommodation on the ground of unavailability of their counsel, Mr. Jishnu Shaha. So there also I am suffering some prejudice. In that case, will Lordship fix it on Monday at a particular time if Lordship is hearing Mr. Chidambaram's
I am-
matter today?
It will anyway come in. I'm opposing,
Why
my
don't
lord.
we start at 2 o'clock and then it's unlikely that parties, the learned council will conclude by 2:45. We'll have to.
Lord,
Oh no,
This
some
is
different
3, my
matter.
lord. My learned friend is strong at 3. I'm opposing that, my lord. That's also they have preferred an appeal, my lord, from that.
19th August.
Oh, I see.
But-
But no, today we are taking a 4 and 5
Yes, 4 and 5. 4
at
and
2
5.
o'clock.
4 and 5.
Obliged
Which is
report.
why I am praying, Lordship, if item number
But
3,
that's
because
19th
there is
August.
some urgency
That's not-
there and there is...
It will retain its position. We are not delisting it.
Hmm.
Come back on Monday. It's very likely to be called on.
Yes.
Very well.
Number 3 new application.
Lordship kindly directs that it will retain its position. That's all.
12 o'clock matter. We'll be back.
Yes, my lord. We'll do so.
Much obliged, Lordship.
12 o'clock.
Yes.
Nice to see, my lord, that your lordship's court has been converted into all India court. This court has also, my lord, the next. There are quite a few lawyers from Delhi, and we are very glad about it.
Yes, of course.
Mhm.
You had last cited 2024 2 SCC
Yes.
577.
I have shown that
Hmm.
for the purpose of, in order to support my submission, that a person who is seeking to establish the goodwill has to, my lord, come forward with some kind of a prima facie evidence at least, that, my lord, the trade dress which for about which, my lord, they had been espousing, my lord, that has my lord, assumed a secondary meaning. For that purpose, my lord, I come back to that. My lord, my submission will be this, that as I told your lordship, in order to succeed in this matter, at the interlocutory stage, the plaintiff will have to establish three things: goodwill, misrepresentation, and damage. My lord, goodwill and reputation, that's the first point. Our submission will be that in order to, my lord, establish the goodwill and reputation, the plaintiff has failed. Why he has said so? Well, I will make my submissions on that. Well, my submission will be this, that in order to establish goodwill and reputation attached to the goods, namely, my lord, the battery, the automotive battery, in the mind of the purchasing public, one has to establish that their association between the identifying get-up and, my lord, the goods concerned. In other words, my lord, one has to establish that there is a goodwill established in respect of the red color. Now, if the goodwill is shown to have been established in the totality of the thing, including the word excite, then, my lord, the goodwill is not attached to the color, the trade dress. That is my submission, respectful submission. So, my lord, the first point that I am making before lordship, that a strong prima facie case of goodwill and reputation has to be established by attaching, by my showing that the goodwill and reputation is attached to the get-up of the goods. That is the red color of the batteries. That is the first thing. My lord, in course of, my lord, the evidence, if the plaintiff shows that the goodwill is attached not only to the trade dress, but also to the brand or the logo, like Excite, or, my lord, if there is a logo in respect of that, then, my lord, the goodwill has not been proved to be in respect of the color. Then, my lord, the plaintiff will fail. In other words, if I may say so, in this way, put it in this way, that the plaintiff not only will have to establish that its reputation in the market is because of the name Excite, but completely dissociated from this brand of Excite, the plaintiff is required also to prove, or rather, the plaintiff will have to prove, for the purpose of establishing, my lord, a case of passing off, that the goodwill is attached to the color itself, independently of, my lord, the brand of the name.
So this is what you had said, that when anybody looks at a red battery, the plaintiff's name will come to mind immediately.
Excite will be the one that will flash in his mind. And here, my lord, I submit to your lordship that the plaintiff will have to demonstrate by evidence that the goodwill or reputation in the get-up or the trade dress is in color red. And this, my lord, is, as has been said, my lord, in 2024, Brihan Karan's case, 2024 two Supreme Court cases, one has to have the, my lord, the language is that prima facie, my lord, they will have to show that this your lordship will please to take, my lord, that I will just remind your lordship. This is at page 100 in the compilation in volume 1. And my lord, the language is this. Para 16 and 17. Para 16 is, my lord, your lordship is pleased to see. I just read it out for your lordship. Prima facie, it appears to us that at the time of final hearing of this, at the time of final hearing of the suit, it was incumbent upon the appellant plaintiff to actually prove the figures of sales and expenditure incurred on the advertising and promotion of the product. Only by producing the statements without proving the contents thereof, the appellants could not have established their reputation or goodwill in connection with the with the goods in question. Then, my lord, I am not troubling your lordship. Then, my lord, para 17. For establishing goodwill of the product, it was necessary for the appellant to prove not only the figure of the sale of the product, but also the expenditure incurred on promotion and advertisement of the product. Then, my lord, next sentence. Prima facie, there is no evidence on this aspect. While deciding an application for temporary injunction, this is what we are concerned with. While deciding an application for a temporary injunction in a suit for passing off, in a given case, the statements of accounts signed by the chartered accountant of the plaintiff indicating the expenses incurred on advertisement and promotion and the figures of sales may constitute material which can be considered for examining whether a prima facie case was made out. But here, I am only putting this rider that this kind of promotion and figures of sales has to, my lord, be associated with the trade dress in respect of which, my lord, the passing off action has been. This is what I am. Well, on this aspect of the matter, I will place before your lordship a judgment which I thought is very instructive. This is a foreign judgment, my lord. If your lordship cannot take the volume 1 of this judgments relied upon by us, this case of BioSteel Incorporated. Here, my lord, there is a clear analysis. Yes, compilation in volume 1, page, the very first, page 1. My lord will be pleased to take, my lord, this judgment. Volume 1, page 1 of, my lord, the compilation of judgments. It is like this, my lord. It is
Yes.
spiral binding. The very first judgment. This is, my lord, Ontario Superior Court of Justice, BioSteel versus, my lord, Sizzle Brands. Can you see the first paragraph, first sentence? The parties are manufacturers of sports hydration drinks and powder mixes. Plaintiffs allege that the defendants have been operating their brand and product known as Swench Hydration in a manner that passes off the goodwill of the plaintiff's brand and product BioSteel. They call Swench an obvious ripoff of BioSteel. They say that the products and flavors are the same as BioSteel's and that the get-ups, meaning the packaging and overall look of its products, are virtually identical to those of the BioSteel. They seek an interlocutory injunction. So this is an interlocutory injunction. My lord, kindly, I'm not troubling your lordship, my lord, with it. Kindly, my lord, come to the law of passing off at page 4. Kindly take, my lord, the paragraph 8. Reckitt and Coleman versus Borden. This is, my lord, 1991 All-England report. I shall place it before your lordship at the proper time. Your lordship will please to see this has summarized, my lord, what the law of passing off is. This is what I have submitted to your lordship. It says, my lord, quoting from the House of Lords judgment of Reckitt and Coleman, the law of passing off can be summarized in one short general proposition. No man may pass off his goods as those of another. More specifically, it may be expressed in terms of elements which the plaintiff in such action has to prove in order to succeed. These are 3 in number. First, he must establish a goodwill or reputation attached to the goods or service which he supplies in the mind of the purchasing public. Kindly note the next word. By association with the identifying get-up, whether it consists simply of a brand name or a trade description or individual features of labeling or packaging, under which the particular goods or services are offered to the public. That's the first point. Such that the get-up is recognized, kindly note this, such that the get-up is recognized by the plaintiff public as distinctive specifically of the plaintiff's goods or services. So the get-up has to be recognized by the public as distinctive. Then second is he must demonstrate misrepresentation, and third he must demonstrate, my lord, that he suffered or likely to suffer damage. My lord, I am not troubling your lordship with my lord. The next, kindly, my lord, come to page 7, paragraph 17. I find that the plaintiffs have not established a strong prima facie case that there is goodwill or reputation attached to the get-up of the goods. In the alternative, they have not raised a serious issue to be tried in this regard. Then, my lord, para 18. In considering this question, I am informed by the Supreme Court of Canada's analysis in Sibagigi case, which considers a claim of passing off in the pharmaceutical industry. As discussed above, the court quoted with approval the House of Lords explanation of the goodwill requirement in Bracket Coleman. The explanation makes it clear that it is not sufficient. If I am emphasizing on the word not, it is not sufficient for a plaintiff claiming the tort of passing off to simply establish the broad goodwill or reputation in its brand name or logo. Rather, the plaintiff must demonstrate the goodwill or reputation attaches to the get-up of its products, with the result that the get-up is associated with the plaintiff alone. This is, my lord, the point I am making. Then, my lord, he must establish goodwill or reputation attached to the goods or services which he supplies in the mind of the purchasing public by association with the identifying get-up. My lord, I am marking these words, identifying get-up, whether it consists simply of a brand name or trade description or individual features of labeling or packaging, under which his particular goods or services are offered to the public, such that the get-up is recognized by the public as distinctive specifically of the plaintiff's goods or services. So, my lord, the get-up has to be recognized by the public as distinctive of specifically of the plaintiff's goods and services. The court in Sibagig's case on to discuss the meaning of get-up as the whole visible external appearance of the goods. Kindly note this. The whole visible external appearance of the goods in the form in which they are likely to be seen by the public before purchase. Well, very nicely put, my lord, and very clearly put. The whole visible external appearance. Well, I am requesting your lordship to look into this. This is what the public sees is, my lord, the red box with excise, mileage, and, my lord, the photograph of a car. All told, the whole visible external appearance of the goods in the form in which they are likely to be seen by the public before the purchase. If goods are sold in packages, then their get-up means the appearance of the pack taken as a whole. And, my lord, when your lordship looks at it, then your lordship will have to decide as to whether, when the package is taken as a whole, if there is any possibility of confusion. Confusion is, my lord, I shall come to the next one. Well, then kindly come to the paragraph 20. Elaborating on the concept of goodwill in get-up of a product, the court explained the product's appearance or its packaging, shape, size, or color may be characteristic of a particular manufacturer and have the effect of marking out the product or making it recognizable as his own. It went on to provide the following example. When the consumer needs removal of self-stick notes, he will look for the small blocks of yellow paper. He may not know the name of the product or manufacturer, but he does not need in order to recognize what he wants to buy. What he has noticed and what he has retained in his specific color of the merchandise. What he has noticed and what he has retained is the specific color of the merchandise. Thus, the goodwill requirement refers to reputation or goodwill in the get-up specifically, and not just in the logo or brand. This analytical focus on the get-up is essential to the claim. For instance, in Kraft Jacobs, the court found that the plaintiffs had established a reputation in the specific get-up of Toblerone chocolate bars, which have a unique design of sectioned peaks or threads and triangular packaging. Conversely, in Unitop, the court found that no such goodwill or reputation was demonstrated in the plaintiff's get-up. Unitop involved a claim of passing off in connection with CSAM Snaps bars. The plaintiff argued that the product's packaging was distinctive and served as a source indicator. The court disagreed, holding that there's no evidence establishing that the purported distinctive blue, white, red, and clear cellophane wrapping in the product's packaging had become distinctive in the minds of ordinary consumers. While this case arose in the context of a motion for default judgment, that distinction is of little import. The court was concerned with the evidence. Well, I am emphasizing on this word. The court was concerned with the evidence required to demonstrate the goodwill in a get-up for the purpose of passing of action. Its analysis is squarely applicable to this matter. The plaintiffs have not made out a strong prima facie case that there is goodwill or reputation in the get-ups of biosteel products, nor have they raised a serious issue to be tried in this regard. To the extent that the plaintiffs have offered evidence of goodwill, they have done so in relation to biosteel brand at large. Thus, they have provided evidence on the growth of net annual sales of biosteel products in the years prior to CCA proceedings. Its net annual sales revenue for the last full fiscal year before the CCA proceeding. Its endorsement deals with the prominent athletes, sports team, and sports leagues, and its share of the sports drink market in Canada during that period. They also offer affidavit evidence confirming the goodwill associated with biosteel brand was a primary driver in their decision to pay what they did for biosteel. Now, pausing here for a moment, insofar as the evidence led by the plaintiff is concerned, in the facts of this instant case, your lordship will be pleased to see that what they have produced before your lordship is their annual accounts and their balance sheet, their director's report, which is concerning the entirety of, my lord, the excise product, which, my lord, in my respectful submission and as per this particular judgment, is not good enough. You will have to show that in the color itself, you have established such goodwill that members of the public will, when they see the red colored battery, they will think that it is excite battery. That kind of evidence you'll have to lead. This, my lord, in my assumption, they have not led. I will show to your lordship what they have relied upon, and I shall try and meet the point afterwards. Now, my lord, in this case, I shall just give you, lordship, give me that their balance sheet. Volume 6. Kindly, my lord, take volume 6 in this condition. Volume 6, my lord, my lord, what they have. Yes. My lord, kindly come to page 867. This is a part of, my lord, the annual accounts and volume 6, page 867. Yes. My lord, this is, your lordship sees at the top, annual report at page 29 of the report. It's annual report of 2019-2020 at the top. And there, my lord, sales, my lord, figures have been given 2010, 11, 2011, 12, like that. up to 2019-20. Then, my lord, your lordship will be pleased to come to and come to that. That next, my lord, kindly come to page. Kindly come to page 870, the balance sheet as on 31st March 2020. This is the total, my lord, sales figure and, my lord, the business that they have done. Quite impressive figure, my lord, I must say. But then, my lord, it is the total figure, the conjoined figure of everything. And this, my lord, the judgment says is not good enough. It says, my lord, this judgment at page 9, which I just now placed before lordship, it says, thus, they have provided evidence of the growth of net annual sales of biosteel products in the years prior to so-and-so proceedings. Its net sales, annual sales revenue for the last full fiscal year before the so-and-so proceeding, its endorsement deals, etc., in prominent athletes, sports teams, etc. And, my lord, it says they also offer affidavit evidence confirming the goodwill associated with biosteel brand was a primary driver in their decision to pay what they did for biosteel. And here also, they have relied on these figures for the purpose of, my lord, establishing their goodwill. Well, it is not a goodwill of the excise. Nobody is, my lord, disputing their goodwill. But what I am submitting to your lordship is, can they say that the goodwill is attached to the red color? When, my lord, their product and their, my lord, the way they produce it before the public is the entirety of the package, including the name and, my lord, the photograph of the car and the whole thing is there. My lord, in this connection, my lord, kindly take, my lord, GA1, para 9 of their petition. Give me the page. (177). That will be in volume 1. Yes. Well, in volume 1, my lord, volume 2, sorry, volume 2, page 177. That's all. Well, let kindly take their own petition at page 177, paragraph 10. Starts from paragraph 8. My lord, I should say, my lord, kindly take para 8, 8, 9, 10. This is the basis of their case. It says the trademark excite has been used by the petitioner since the year 1920 in connection with lead-acid automotive batteries, and the same continues to the petitioner's primary offering under such trademark. The trademark excite they are talking of. Other than the fact that the corporate name of the petitioner comprising of the said trademark is used for all its product offerings, the petitioner also uses Excite as a brand for many of its products, such as automotive batteries, Excite and variants, solar products, services, solutions, Excite, Excite Sunday, inverter batteries, Excite Inva series, home UPS systems, Excite inverters, integrated power backup systems, Excite Integra, distilled water, Excite Distiller, and many others. The subsidiary of the petitioner, that is Excite Energy Solutions Limited, also uses the name Excite as a part of its corporate name. The petitioner's entire range of offerings under the said trademark Exide and its general credentials can be viewed on the website of so and so. Then I'll kindly come to para 9. The trademark Exide, while functioning as a flagship brand of the petitioner, also forms part of the corporate name of the petitioner. Therefore, the entire business prowess, business interest, and goodwill and reputation of the petitioner company can be directly linked to the trademark Exide. The petitioner is the owner of several trademarks registrations comprising an Exide, including the word mark thereof, a search report. Then para 10. First of all, place this. Then para 10. The petitioner has always used a distinctive colored theme. Now, what color is coming up? With a predominantly red color in connection with its products, trade dress, and get-up, in connection with inter alia the Exide branded products, including lead acid batteries for vehicles, storage batteries, industrial batteries, inverter batteries, uninterrupted power supply system batteries, and other such products. The distinctive red color has been used by the petitioner in connection with its products under its flagship brand Exide, and also as a part of the petitioner's company's corporate communications, corporate documents, etc. The color red has been used by the petitioner for its products ever since the launch of the petitioner's product in the year 1920, and has become associated with the petitioner, especially in relation to lead acid batteries. Commencing with the marking products with the trademark Exide in red color font, note this, commencing with the marking products with the trademark Exide in red colored font on automotive batteries, the use of the color red in connection with the petitioner's business has grown over the years with the advent and growth of the color printing. The petitioner also uses a distinctive red and white color combination for its product, which inter alia comprises of the colored packaging, get-up and trade dress, accompanied with the brand Exide depicted in white color. The use of the color red and or combination of the red and white by the petitioner includes but is not limited to the following. Then, my lord, I shall take your lordship into this. Now, my lord, kindly note one thing, that Exide, when, my lord, it comes in the car, a new vehicle is purchased, and, my lord, it is fitted with Exide battery. The Exide battery is like this. White, on white, my lord, the Exide is written. The reason is, my lord, it is transparent is there. One can see the quantum of water there. So that is why it is like this. Then, my lord, apart from this, in white with red, they have got the red batteries, they have got blue batteries, they have got, I shall show to your lordship, they themselves have shown this in their annexures. So, my lord, I will my submission before your lordship is this, that what we know of Exide is the name, is the brand, is the logo. The color is, my lord, subservient to it. It is not so important. We do not, my lord, attach much importance on the color because after all, at the end of the day, it is your lordship's perception. So on the basis of whatever materials is available before your lordship, ultimately, my lord, your lordship's perception will be the most important factor at the interim stage. Of course, when the suit will be heard, evidence will be led, the parties will know exactly where they stand. But at the moment, my lord, ultimately your lordship's perception, but I am submitting to your lordship that your perception should be on the basis of available materials before you. The perception cannot be formed, my lord, in vacuum. That will be my respectful submission. And when your lordship looks into the totality of things, my submission is that perhaps the importance of the battery of the plaintiff will be found to be attached to not to the color, but to the brand. And this is what, my lord, this judgment says you cannot do. Well, as Velan Jr. points out, that in para 9, they are saying that therefore, this I have just now placed, but my lord, reiterate this. The second sentence in para 9, therefore, the entire business prowess, business interest, and goodwill and reputation of petitioner company can be directly linked with the trademark Excite. This is the correct thing. And that is so. I, my lord, go and buy Excite battery, not because it is red color. I buy it because it is Excite. In fact, the learned trial judge was pleased to ask me, which battery do you buy? I said, I buy Excite. I go and buy it. I will not buy Elito because it is red. I will not buy Excite because it is red. I will buy Excite because it is Excite. And this is what they are saying. The entire business prowess, business interest, and goodwill and reputation of the petitioner company can be directly linked to the trademark Excite. Then, my lord, I will just conclude, my lord, this judgment on this aspect of the matter. Kindly come back to page 9. I have this. I shall come to that. Kindly, my lord, come to page 10 of this judgment. I shall come back to it, the evidence part of it. This is, my lord, summarizing what needs to be done, my lord, in a passing of action. For the purpose of passing of doctrine, however, this evidence is not sufficient. The plaintiffs cannot just provide evidence of goodwill in BioSteel's business, brand, and full suite of products as a whole. They must show the goodwill can be attributed to the get-ups of BioSteel products at issue. That is, they must demonstrate the consumers exclusively associate the get-ups of BioSteel products, including its packaging, coloring, and imaging, with BioSteel only. In the same way, the hypothetical consumer in Shivaji's case associate small blocks of yellow paper with removable self-stick notes, or consumers were found by the court in Kraft Jacobs to associate chocolate bars with the section peaks and triangular packaging with Toblerone itself. The plaintiffs have not met this burden. My lord, I have shown to your lordship paragraph 8 and 9, my lord, your lordship, and pleased to see. Now, your lordship kindly takes this, my lord, kindly come to page 178 of this volume 2, their own petition. Lordship will please to see this. Depiction of A is depiction of trademark Excite in red colored font on batteries and packaging thereof are annexed here 2 and collectively marked annexure D. Now, this annexure D is page 294 of the same volume. Depiction of the trademark Excite in red colored font in batteries. And this they are showing, my lord, at page 295 is, your lordship will kindly take, my lord, page 295 to 299. Yes, kindly see, my lord, 295. It's the one is red box with white Excite. The other is the one that is there before your lordship. This white, or rather grayish white, I should say, with Excite in red. This is the one, my lord, it is in front of your lordship. This has been shown that red font of Excite written. Then, my lord, B is batteries and packaging of batteries with a prominently red color are annexed here 2 and marked annexure E. Now, that your lordship will be pleased to find in volume 3. That is at page 305. Showing, my lord, red colored battery with white font of Excite matrix. Then at page 308, we are showing red colored batteries with Excite written. Then, my lord, red leads had been referred to in subparagraph C. Page 314 also, your lordship is pleased to see. This is also B, a part of annexure D. Page 314. Red battery, this is what, my lord, is your lordship sees in front of you. Page 314. 60 months warranty written over there. Excite mileage, this is exactly the same with the picture of a car, vehicle. Then, my lord, annexure F, that is at
325. 325.
325, yes. 325. That is, my lord, they are saying red lids and red colored labels on select factory fitted batteries in vehicles. The top of the battery had been given red. And my lord, kindly come to page 329. In this very annexure, they have given live fast, which has also got a red lid. Authorized distributor, live fast Excite. Then inverter battery at page 330, tube aster with red lid, and but the white body with some kind of a design. Tube aster. Then annexure G, my lord, predominantly red colored products such as inverters. Annexure G. They have been given these, my lord. At page 339, the inverter says it's a biggish picture. 341 is also the same. Then distinctive red theme advertisement in newspaper. That is annexure H. Annexure H, at page 346, my lord, the advertisement. But this, of course, I'm not sure what color it is at page 347. It looks like gray here, but maybe, my lord, because of the print. Side. Well, this is of 1920, if your lordship sees that. Page 347, February 18th. Aeroplane, February 18th, 1920. The next one is 1921. There is really, my lord, there is nothing red here, excepting this, my lord, what they are contending, perhaps that they convert it into red batteries afterwards. Then, my lord, they have given in annexure H the advertisement in the newspapers and all. Page 361, your lordship sees black battery. We have seen this. I don't know whether your lordship has seen this. We have seen this, my lord. This is the battery that we have.
Black I've seen. You have?
In fact, my lord, the batteries used to be black.
Yes.
During my time. if I may use that expression.
Correct.
Now it has become red, green, yellow, different colors.
What is there at 362?
362 is my lord. Let me see.
To win Melbourne,
Kohli has tossed.
Kohli has to win toss.
Yes.
I mean, what does this have to do with battery?
My lord, the exide is written at the bottom in small letters. That is in red font. In that very advertisement.
Oh,
So I suppose, my lord, for that. Can we come to page 364? Interesting.
was Excite previously known as Chloride Industries Limited? No, Chloride. The name is.
Chloride company was chloride,
Yes.
Okay.
and then my lord, the products, my lord, were both chloride and exide.
Acha.
Today also it's the same. My lord, there's a chloride, and my lord, there is an exide. My lord, it changed to exide, my lord, because of a litigation. My lord, the American company wanted to enter India with exide.
I see.
Though there had been a separation, parting of ways, my lord, pursuant to a master agreement. My lord, in fact, the parents were appearing in the matter. My lord, there was litigation, my lord, in Delhi, my lord, which, my lord, Exide succeeded.
I see.
Indian Exide.
In fact, I don't know whether you remember, previously the building on the corner of
Chorungi,
Chorungi,
opposite Calcutta.
it used to be chloride.
Correct.
At the it used to be written chloride.
Now it's Excite House,
Now it
isn't
is
it?
Exide.
My lord, after Birla management, my lord, lost. My lord, and my lord, Raheja management took over, my lord. My lord, all these changes, my lord, have happened. Birla's used it as chloride.
Page 367, perhaps,
But
is building.
battery was Exide.
Battery was Excite.
My lord, business name was chloride. That's
Page 367 is the building that I am referring to. So they are saying that it is red at the top with Exide font, my lord, in white. Now, my lord, we have stated, my lord, insofar as this is concerned. My lord, before I do that, my lord, apart from this judgment, my lord, there is another judgment I would like to place before your lordship before I go into the facts of our case. Your lordship will please to take, my lord, the very same volume, page. Cornice কোথায় গেল? Cornice is in volume 1, na? Volume, sorry. Well, it is volume 2, your lordship will please to take other judgment. Well, kindly come to page 354, the Forney's judgment. Forney versus Daco. This has been referred to in the judgment itself, the impugned judgment. This has been referred to because these were cited on page 355, second volume, page 355. We shall come to the AO. I have not come to the AO yet. Because next I shall go into the AO with regard to our governance. Lordship will please to come to page 370. My lord, the judgment starts at page 355. My lord, kindly come to the first paragraph. Kindly see the facts of this case. Plaintiff Forney Industries manufactures and sells variety of products. Its largest product line is retail metal working parts and accessories. The issue in this case is whether the use of color in its packaging of that product line is protected mark under Section 43A of Lanham Act. Cornish packaging has, since at least 1989, used some combination of red, yellow, black, and white coloration. It describes the mark it seeks to protect as follows, and then, my lord, it has gone on. Well, I take your lordship, kindly come to page 370. Page 370. Last paragraph, inherent distinctiveness. Our examination of Forney's arguments that its trade dress is inherently distinctive begins with Forney's description of packaging for its product line. In its brief to us, Forney defines its trade dress as follows. Then the description is there. The Forney color mark is a combination of arrangement of colors defined by a red into yellow background with a black banner oblique header that includes the white letters. More specifically, the Forney color mark includes red and yellow as the dominant it should be background colors. Red typically starts at the bottom of the packaging, continues up the packaging, and may form borders. Red may also be used in accents, including but not limited to lettering. Yellow typically begins higher than red and continues up the packaging. Yellow may also provide border and be used in accents, including but not limited to lettering. A black banner is positioned towards the top of the package label or backer card. Black may also be used in accents, including but not limited to lettering. White is used in lettering and accents. Then 1252. We question whether the description would satisfy the articulation requirement for a protectable mark. Several courts have adopted a requirement that a plaintiff seeking to protect his unregistered trade dress do more than just point to the overall look of its trade dress. It must articulate the specific elements which comprise the distinct dress. I'm page 371. 371 is the 1252, paragraph 1252. It must articulate the specific elements which comprise its distinct dress. Then, my lord, it is the plaintiff's duty to articulate the specific elements which comprise its distinct dress. Then it will not do so. It will not do to solely identify in litigation a combination as the trade dress. Rather, the discrete elements which make up the combination should be separated out and identified in a list. Brackets in the trade dress appears the products are not identical, courts have declared so and so. Then plaintiff asserting that a trade dress protects an entire line of different products must articulate the specific common elements sought to be protected. There are several reasons for not protecting a vaguely defined trade dress. To begin with, without a precise expression of the character and scope of the claimed trade dress, litigation will be difficult, as courts will be unable to evaluate how unique and unexpected a design element are in the relevant market. Similarly, its descriptions are vague. Jurors viewing the same line of products may conceive the trade dress in terms of different elements and features, so that the verdict may be based on inconsistent finding. Then, my lord, kindly come to the last paragraph just before, my lord, not the last paragraph, the penultimate paragraph before the secondary meaning. In short, Forney has used a combination of red, yellow, white, and black in such diverse ways that there is no consistent shape, pattern, or design we can discern from its description of its mark or from the examples it provides. Particularly in the light of Supreme Court's instructions to be cautious about the applying vague litigation-friendly tests for inherent distinctiveness, we conclude that Forney has failed to establish an inherent distinctive trade dress. Then, my lord, secondary meaning, it has gone on. Kindly, my lord, come to page 373. point out something which you have missed out. Yes, this is the summary of that in short. This has been summarized here. So, but page 373, the penultimate paragraph, Forney does not point to any direct evidence of secondary meaning, but does list 3 items from an affidavit by CEO Stephen Anderson that it argues to meet its burden. 1. Forney's extensive promotional and advertising efforts at more than 10,000 stores that featured products bearing the Forney color mark in Forney displays over each of the past 25 years. Then 2, Forney has over $500 million in sales of over 4,000 different products bearing the Forney color mark over 25 past years from Forney's display. And 3, Forney's display provide constant connection between Forney's color mark and Forney source. Then, my lord, we agree that advertising can be strongly probative. For instance, in so and so, in Owen's case, Corning, one of the preeminent trade dress color cases, the court looked at that advertising that highlight the pink color and of the product. Then, my lord, Owens Corning had used the Pink Panther in commercials that told consumers that they can cut high cost of fuel if they would only add another layer of pink in their attics. And it has slogans in the advertising such as pink of perfection, the pink cooler, the Pink Panther is not there. Pink cooler, pink, love that pink, pink power, America's favorite pink product, tickle pink, put your house in pink, up with pink, prime time pink, think more pink, beat the cold pink, all that pink, etc. Some pink insulations in your attic. The court said that this broad promotion of pink in association with Owen Corning fibrous glass residential insulation is of evidentiary value. So, my lord, here the advertisement was with regard to pink. And my lord, all these things is coming together, put together, my lord, had given pink a distinctive feature. That's what is being said. But advertising alone is typically unhelpful to prove secondary meaning when it is not directed at highlighting the trade dress. Secondary meaning cannot usually be proven by advertising that merely pictures the claim trade dress and does nothing to emphasize it or call attention to it. To demonstrate secondary meaning based on advertising, the advertising must be of a nature and extend to create an association of the trade dress with the advertiser's goods. This is, my lord, what I have been submitting to your lordship. Forney's advertising utterly fails to mention the color mark or to emphasize it in any fashion. On appeal, Forney does nothing to challenge the characterization or otherwise show how the advertising was directed at highlighting the trade dress. Forney's evidence of sales data is similarly unavailing. It provides total sales volume, but gives no indication of how those sales relate to the color mark. Sales volume only suggests secondary meaning when presented in conjunction with other evidence. Standing alone, sales volume may not be indicative of the secondary meaning because it could be related to factors other than the source identification. Then evidence that its products had millions of users and that its products are sold through well-known retailers does not tell us whether the sales were stimulated by the mark. Now, my lord, this is another judgment which highlights the importance of the trade dress being advertised as the primary feature, as in the case of pink. So, my lord, really, my lord, one has to, so to say, put emphasis for the purpose of, my lord, creating a goodwill, a reputation, in order to, my lord, sustain an action of, my lord, an action of passing off, my lord, one has to show that the red was advertised as the one of the primary objects which had attracted the attention of the customers, because ultimately it is the customer's reaction. Here, my lord, my submission is this, that the red is just, my lord, is one of the, so to say, a background of the goods which is sought to be sold, without it creating any impact on the perception of the public. Let me put it this way. And, my lord, they have themselves said, and I agree with that, that it is excite. That is the primary thing. And the red just happens to be one of the appendages. Had it been, my lord, excite with blue, excite would have sold. Had it been excite with gray, excite would have sold. Because it is the name of excite, it is the brand excite which is of importance. It's only evidentially aspects of what exactly is. Here is the whole number. 372 bottom. Well, in this connection, kindly come back to page 372. B, the secondary meaning, the last paragraph. We therefore turn to the evidence of secondary meaning. Trade dress is said to have developed secondary meaning when in the minds of the public, the primary significance of the mark is to identify the source of the product rather than the product itself. This is Walmart store's case. Forney has the burden of persuasion on the issue, because Seven failed to raise a fact issue as to the inherent distinctiveness of secondary meaning. It failed to satisfy the summary judgment burden on its trade dress claim. The existence of secondary meaning is a question of fact, with the burden of proof on the party claiming exclusive rights in the designation. Secondary meaning can be established through direct evidence, such as consumer surveys or testimony of consumers. Then, well, internal question mark omitted, but a plaintiff can also rely on circumstantial evidence, such as the length and the manner of the trade dress use, the nature and extent of advertising, promotion of the trade dress, the efforts made in the direction of promoting conscious connection in the public spine between the trade dress and the particular product or venture, actual consumer confusion, proof of intentional copying of, evidence of sales volume. Now, my lord, I am submitting to your lordship that in the facts of this instant case, what is happening is this, that persons who are going in for, this is an expensive item. This is not, my lord, small things like, my lord, chocolates, or, my lord, even medicines. I shall come back to medicines. There are, my lord, different judgments on the case of medicine. There, the courts have said that even though there are doctors' prescriptions are there, a person goes into the shop and, my lord, immediate urgency is there, and therefore he buys the thing without looking into the. But, my lord, insofar as the expensive things are concerned, on evidence on record, the battery, this Excite battery is 4,800. Evidence on record, so far as Amara Raja battery is concerned, is about 4,000 rupees. Both are, my lord, expensive goods. And, my lord, when one buys expensive goods, one is not careless, because one's good money is being spent for the purpose of purchasing that. So, my lord, one is more careful about that. And this is exactly what has happened. And I have led evidence on that. I shall just draw your lordship's attention in this connection at this moment to, my lord, 2 paragraphs in our affidavit, which perhaps, my lord, will show as to, my lord, how we have dealt with it. My lord, kindly take volume 12. Volume 12 here. Kindly take, my lord, volume 12. This is, my lord, the affidavit evidence, and Kindly come to page 1730. The affidavit starts, well, affidavit starts at page 2. At page 170, 1710, the affidavit starts. Kindly come to my lord, page 1730.
This is your affidavit with the learned single judge.
Yes. Para 30. I state that automotive batteries are not products that are purchased by an average consumer based on color. Color of a battery is not a predominant or primary factor in making a purchase of an automotive battery. For purchasing, a consumer does not browse the shelf and pick out a battery based on color. The choice of buying an automotive battery depends on the model and make of the vehicle, which would require either research to be done by the customer beforehand or taking the advice of the concerned dealer or the mechanic as to which battery would be suitable for the particular make and model of the automotive. Price and warranty period of various batteries that are available for a particular make and model of a car also plays a role in making the decision of choosing the brand of battery. A significant factor that plays a role is the brand preference, where the consumer will come and ask for the name of a particular brand from the dealer. Then I state that the plaintiff has also attempted to create an impression as if it has only and always sold products in red color. I shall come to that afterwards. These are, my lord, this is one thing we have said. Then, my lord, kindly come to para 63.
This point, sir. Car comes battery fitted. Car comes like this white battery. So there is already a model, there is already a battery.
My lord, this is also we have said that when the cars come, when I purchase the car, it is fitted with the battery. The battery which is most suited to for that particular car, for that particular model. My lord, for a Toyota, one size, and my lord, a particular way. For a BMW, something different. Maybe for a Mercedes, something else. Now, my lord, when the car comes, my lord, it is fitted with the battery. And generally, what happens is this: when you replace the battery with the same brand. You don't change the brand halfway through, and this is what.
Same model number on all brands.
And my lord, the model numbers are also mentioned in the same brand. My lord, kindly come to page 1750 of my affidavit. In para 61, my lord, we have shown the differences in the batteries, the two batteries. And after that, para 63, I state that it is important to bear in mind that the products involved in the present dispute are automotive batteries. It is not a product which a consumer buys based on color. In most cases, an average consumer knows which brand of battery is to be used in the car. The other scenario is that the consumer will take advice of the dealer selling the automotive battery. And even then, such dealer would know the specifics of each brand very well. Thus, it is unimaginable that one would purchase red battery or a green battery for their car. I further state the defendant is one of the largest players in the automotive industry and enjoys tremendous goodwill and reputation. It has been manufacturing industrial batteries since 1985 and automotive batteries since 2000. The annual turnover of the defendant company for the financial year 2023-24 was approximately Indian rupees, my lord, 11,260 crores. The defendant has absolutely no incentive for inducing customers to believe that they are purchasing plaintiff's product, which is its biggest competitor in the market. In fact, such confusion or deception would actually harm the defendant's goodwill and dilute its brand value. The defendant is not a fly-by-night operator seeking to make a quick profit by piggybacking on the plaintiff. My lord, This also we put it on record by UFN, our submission. My lord, kindly take volume 29. Since I am on this, my lord, I want to conclude my submission. Volume 29. He must be here somewhere. Kindly give me 1 second, my lord. Yeah, this is here. This is here. My lord, kindly come take, my lord, para 12 of this. Written notes of submissions. 4200.
Answer which page you want?
4220. Para 12.
Connection E. Connection 4211 and 423.
Yes. 4220. Your lordship has got that?
4222.
4220.
4220.
Para 12. There is no likelihood, not deceptive, sir. There is no likelihood of confusion whatsoever, as a customer who seeks to purchase an automotive battery does not make a purchase decision based solely or even primarily on the color of the battery. In this regard, it is submitted as under. Batteries are sold and recognized by customers primarily by their brand name, Exide, Amaron, etc. Then B, automotive battery is an expensive product and is not a casual purchase, unlike toothpaste or duster cloth. Even according to Exide, their battery costs rupees 4,819 and Amara Elito battery costs 4,052. The paragraphs have been stated. This is not a regular or frequent purchase, but typically takes place only once every 2-3 years for an automobile. Further, automotive batteries are not one of many items sold in a general store. There are specialized stores for automotive batteries. Then E, in such stores, the dealers would inquire about the vehicle for which the battery is needed. Then either the dealer would suggest options, give recommendations, or the customer would ask for a specific brand of battery, either the same brand that is already installed in the vehicle, if they are satisfied with the performance, or another specific brand such as Exide, Amaron, etc. And 2, inquire the price of the various brands. So this is also an important factor. And then decide based on one or more of the above considerations. Then F, further, the batteries are specific to the make and model of automobile. Therefore, an appropriate automotive battery must be selected for the specific make and model of the customer's vehicle. This selection is done, one, either by the customer by researching on their own websites of Exide as well as Amara, allow persons to check the relevant models of each battery brand for specific make and models of the automobile, or by seeking advice from the battery retailer or the service center where the customer goes to get the battery changed. Then G, there is no evidence whatsoever that customer browse the store and pick up the battery on their own, or that customer asks the dealers to give them a red battery when they want an Exide battery.
We'll have to stop here today, Mr. Mitro. Has to be after vacation. Next week it's not not possible.
Yeah.
So give us a date, Mr. Luthra. Give us a date. After we
will continue, I believe, for a while. So next year I may do VC, but I'll come after that.
we reopen on the 24th of October.
Yes. Then a week after that.
Dekho, diary, dekho.
After the first, my lord had indicated.
After the 1st of November.
What my lord had indicated last time. There will be a lot of load on other matters that.
4th November. 4th November.
ঠিক আছে 4th is fine.
4th November কি বার পড়ছে?
Tuesday?
Tuesday.
My lord, is 5th possible?
5th is a holiday?
Holiday.
5th is a holiday. Why? I don't know, but it's a
But
holiday.
then in any case,
Fifth, I
But
think
it's Guru Nanak's
Oh,
not on
5th.
4th, I will do it on VC. But my learned senior will, we all come after that.
Roughly how much time will take, Mr.
I will
Mitra?
take some time, my lord.
No, no
At-
problem.
two hearings, my lord.
2 hearings.
Two hearings.
Very well, then, Lekho. Mr. Mitro, learned senior counsel representing the appellant, resumes his argument but does not conclude. Paragraph as jointly agreed by learned advocates for the parties, list this matter once again on November 4, 2025, uh, so two hearings of 1 hour will
I
suffice.
think it should be okay.
3:30, mark 3:30 p.m.
And then
Yeah,
subject-
3:30 is
After, yes, we'll hear you after that.
Well, 3
Tuesday 3:30, no problem. Friday, yes.
Well, who am I to predict? Well, two things, my lord, I am praying before Lordship. First is, my lord, the interim order is expiring on the 25th of September. My lord, kindly direct the interim order to
What interim order is there?
trial court order is this, that I am to comply with the order of the court by 25th September. So, my lord, I will respect.
My lord, I can, my lord, make a statement that, my lord, will take no coercive steps.
Well, let
Record
there
that.
be, let there be an order.
let there be-
Yes,
Let there
yes.
be an order. I don't think there should be any problem.
No.
No.
Will not take any coercive steps, my lord, while
Let the order be kept in the bench till we have the.
Paragraph Lekho. Learned single judge had granted the defendant, public appellant, time till September 25,
Right.
2025, to comply with the directions of the learned single judge. Stop. In view of the fact that we are hearing out this appeal and the puja vacation intervenes, the appellant says that there should the time for complying with the order should stand extended. Paragraph, Mr. Mukherjee, learned senior counsel, representing the respondent oblique plaintiff, says that no coercive action will be taken by the plaintiff in view of pendency of this appeal. Stop.
my lord, till, my lord, the date fixed. After that, my lord, no matter. Oh, my lord,
During
my lord,
pendency of the appeal.
Yes,
Yeah.
yes.
That is good. I think that's good. Let us not.
That is all. That statement is sufficient.
Well, second prayer. There is one. That's the one prayer. Second prayer is, my lord,
my lord,
kindly make it parted. No, because otherwise, if there's a change of the bench,
No, Mr. Mitro, then again, if there's a change and if we are not together, it will be very difficult for us to
my lord, then
assemble.
kindly, my lord, extend the order
Hmm.
rather than, my lord, my lord, statement. Kindly
Very good.
extend it, my lord, and my lord, only
So
one.
Mukherjee Mr. Mukherjee diye.
Kindly
Well,
extend it, my lord, to whichever date, my lord, your lordships, and then, my lord.
we think that this is a fair suggestion. Stop. Huh? The time for the appellant oblique defendant to comply with the order of the learned single judge stands extended till the end of November.
Till disposal.
Till disposal. Let it be till disposal.
My lord, I have not yet spoken, my lord.
No,
my lord.
yes, but then we are hearing out the appeal.
No, true.
No prima facie case.
My lord, no, absolutely, my lord. I'm not, my lord, we are before
November
your lordship.
2025.
My lord, may I tell your lordship, my lord, the difficulty, your lordship didn't make it parted. Now, my lord,
No, we are not.
correct.
No.
Now, my lord, that's the problem.
Hmm.
My lord, I
That is
wouldn't
the
have
problem.
worried then, my lord. Come
kindly
out,
make
my
it
lord,
parted.
date.
It's a joint prayer, and your lordships do not have any problem in that.
My lord, they প্রবলেম হলো ওরা একসঙ্গে বসবে না তখন মুশকিল হয়ে
And শ্রমিক
till-
পেলে
till- till disposal of appeal করে দাও তাহলে তারপরে লেখো learned senior counsel for both the parties strongly request us to mark the matter as heard in part to inverted commas with stop in view of the fact that we have heard this matter extensively comma. Let the matter be marked part heard.
My lord,
Part heard
only
till the-
one request I have, your lordships. My lord, they should, my lord, indicate to your lordships, my lord, the, my lord, amount of batteries, my lord, which are, my lord, manufactured and
In my,
with your lordship.
not
They-
now.
No, why?
I-
My lord,
I will
they are
submit to
seeking
lordship,
time to comply,
No.
my lord, with the order. My lord,
My lord,
my lord, we should, my lord, at
in
least,
fact,
my
my
lord,
lord, I had hesitation in my lord having this in this order which has been passed.
117.
Yeah.
At 2 o'clock, we have to hear Mr. Chidambaram. Let
Okay,
us go.
My lord,
Yes, we have said nothing. We have, you know.
no.
My lord, fours. So should I do mine first? Yeah. My lord, want to keep it, my lord, in a very short compass.
Which is what, 4 or 5?
4, my lord. I'm appearing, my lord, for the appellant. My lord, in my lord, item 4. My lord, a suit, my lord, was filed, my lord, by statesman.
Statesman.
Yes. My lord, challenging, my lord, a sale, my lord, made in favor of, my lord, my clients. The ground of challenge was that, my lord, the sale was on violation of a joint development agreement. Now, my lord, we, my lord, have, my lord, paid good money of 235 crores. 235 crores.
Paid
to, my lord, their, my lord, power of attorney holder, my lord, Merlin, who is, my lord, the appellant in, my lord, item number 5.
Both appeals from the same order.
Yes, from the same order. My lord, I am out of pocket by 235 crores. My lord, there's a registered deed of conveyance, my lord, in my favor. And, my lord, the, my lord, clauses, my lord, in the joint development agreement clearly show that all that, my lord, statesman, my lord, is entitled to. According to us, it's in accordance with, my lord, the joint development agreement. There was a power of attorney as well.
Joint development agreement between?
Merlin and statesman. My lord, the project was to develop, my lord, Statesman House.
Here in Calcutta?
Yes, my lord, to keep, my lord, the heritage portion and then, my lord, develop it, my lord, as a commercial premises. And, my lord, the owner, statesman, was to only retain, my lord, on the 3rd floor, 1,500 square feet. The rest, my lord, was, my lord, as per development agreement, 47.5, my lord, developers, my lord, share, my lord, sale of proceeds, and, my lord, 52.5, my lord, to, my lord, statesman. This is, my lord, the development agreement. It's entirely in money. Now, my lord, during, my lord,
52.5 to statesman.
is to the owners, my lord, of the sale proceeds. My lord, it will be developed. Units, my lord, would be sold. Developer was given a power of attorney, my lord, to sell. And, my lord, the monies, my lord, which came in, 52.5, my lord, would go to statesman. And, my lord, 47.5, my lord, would be, my lord, with the developer. And, my lord, 1,500 square feet, my lord, they retain on the 3rd floor as office space. So, my lord, all that they were to get, my lord, was money. Now, my lord, we put in, my lord, 235 crores to, my lord, Merlin, who, my lord, entered into, my lord, this, my lord, conveyance on the basis of the power of attorney. And, my lord, importantly, my lord, my lord, resolution passed, my lord, and a minute, my lord, which was agreed upon, my lord, which is basically a modality of working the joint development agreement, my lord, which provided, my lord, statesman would buy out, my lord, Merlin's interest for a particular amount of money within a particular point of time. In the event of their failure to do so, my lord, Merlin would be free, my lord, to deal with the property, my lord, in whichever way, my lord, they thought fit. Because, my lord, money, my lord, was owed, my lord, by statesman, my lord, to Merlin. My lord, loans, etc. had been taken. My lord, that time came, my lord, for statesmen to buy. They did not, my lord, buy. My lord, the arrangement was, my lord, the minutes of the meeting record, which is undisputed. There's no dispute with regard to that. My lord, that, my lord, they would, my lord, then, my lord, be able to deal with the property not only, my lord, by, my lord, sale, but also, my lord, by granting leases. My lord, there have been leases, my lord, which have been granted. My lord, like, my lord, what's that store? West Side. My lord, West Side. Yes, Trent Limited, my lord, West Side, my lord, also has a lease.
Property has been developed.
Yes, completion certificate given, my lord, possession, my lord. Possession, my lord, also, my lord, made over to me. And my lord, the order has been passed, and your lordship will find that there is not one finding, my lord, against my client. Not one.
Who's for statesman? Acha.
My lord, this is, my lord, what has happened. So, my lord, my first submission, my lord, before your lordship, my lord, is, my lord, any right that statesman had, my lord, in respect of this property, my lord, under
What order has been passed against
my lord, total injunction, my lord, I can't do, my lord, I'm out of money, I can't deal with the property. Now, the entire property. And I am, my lord, the one, my lord, who has put in, my lord, 235 crores. It's an unconditional statesman, my lord, has not put in a penny, my lord, unconditional, my lord, injunction. My lord, that's between Merlin, my lord, and them. But the fact is, records show that, my lord, Merlin is owed, my lord, a huge amount of money, my lord, by statesmen. But, my lord, I have paid 235 crores.
What have you got in return?
My lord, the property which is now, my lord, I can't deal with. It's a commercial property.
You didn't get the entire property.
Entire property, yes.
Oh, because statesman couldn't buy out Merlin's
Correct,
share within the
correct,
stipulated
correct,
time period, Merlin, as the power of attorney holder, entered into the conveyance with you.
Correct. Absolutely. My lord, that is number one. My lord, it's, and my lord, if I show the development agreement, my lord, it's clear, my lord, that the only, my lord, right statesman has, my lord, in respect of a sale, my lord, is 52.5% of the sale proceeds. My lord, it's, my lord, in money, my lord, at the highest that it can have a claim. And my lord, whatever interstate dispute Merlin and statesman have, my lord, I'm not concerned with. I'm out of pocket, my lord, by 235 crores. I have a conveyance in my favor. And my lord, I'm in possession.
Allow us to go through the order once.
Yes, my lord. My lord, the finding is, my lord, from page 9 of, my lord, the order. I haven't given them in. Yeah, correct.
Yes.
Yes. Now, my lord, I just want to show your lordships, my lord.
The learned judge's sole logic seems to be that minutes of the meeting cannot affect the agreement. The minutes were not incorporated in the agreement. The agreement did not authorize you. Therefore, injunction.
Yes,
Let us hear Mr. Sen.
So there are two appeals, one by.
Yes,
It's the same
you are not
content.
affected, perhaps, are you?
I am. I am because I have signed a deed of conveyance to appellant and item
Yes, Hatishala.
Atisha. I am affected because Atishala
Hey, microphone to adjust, brother.
Atishala may proceed against me if I don't make good on the conveyance. Because according to the learned judge, because the minutes of meeting don't specify the clause of the development agreement, which is amended, the minutes of the meeting cannot be enforced and cannot be acted upon. Therefore, if Hatisala is affected, he may proceed against me. But be that as it may, I just want to make 2 points. One, your lordships have settled the law from many, many years ago that the plaintiff on the date of the plaint who's not in possession cannot get an injunction. Any number of judgments, I'll cite judgments. Admittedly, on the date of the plaint, he was not in possession. He executed 5 documents on 26/3/2019. The development agreement, the declaration, the mortgage deed, a power of attorney, and a letter handing over possession to me on 26/3/2019. In the learned, before the learned single judge, he suppressed the letter of possession. I filed it. Kindly see page 37 of the paper. 37 of the IA 37. Yeah. Kindly see page 37, immediately after the judgment. Judgments. I've got it. All 5 documents were executed on 26/3/2019. Development agreement, mortgage deed, power of attorney, declaration, and this letter. By an agreement of date, we have appointed you as a developer to develop the subject property. In terms of the said agreement, we do hereby hand over to you the vacant and peaceful possession of the subject property, except the portions occupied by HDFC, they have vacated it, and our office portion on the certain portion of the 3rd floor, 1,500 square feet. The entire building was handed over to me on 26/3/2019. When I executed a deed of conveyance, I handed over possession to him. Now, how can the plaintiff maintain a suit filed in 2025 and get an injunction against the persons in possession? Number one. Number two, your lordships have also settled, unless he makes a prayer for recovery of possession, he can't ask for an injunction for possession. That's also covered by authority. Now kindly see suit. The prayers in the suit at 95. The suit starts, my lord, at page I just want to show one portion of the plaint. Plaint starts at page 72. My lords have page 72.
Yes.
Now, turn over the page. 73 and 70. Kindly come to 76, paragraph 11. The best explanation is it's a Freudian slip. Now, please see paragraph 11. At the instance of the defendant number 1, the plaintiff was required to sign the following documents. 1. Joint development agreement dated 26/3, power of attorney, deed of mortgage, deed of guarantee, deed of declaration. He typed 6, but left it blank. That is the letter of possession dated 26/3/2019. Unless this is a Freudian slip. He signed 6 documents and then kindly come to the prayers. 95. A decree of declaration that the agreement and the power of attorney are cancelled. B, decree for declaration that the deed of conveyance executed by me, Merlin, to Harisala is cancelled. Decree of declaration that the plaintiff is a sole and absolute owner of the premises number 4, etc., etc. D, decree of declaration that the plaintiff has a right to redeem the mortgage created in respect of premises. He owes me 160 crore. E, decree of perpetual injunction restraining the defendants and each one of them from dealing with, disposing of, and encumbering or creating any third-party interest or interfering with the possession of the plaintiff. Great. Wait a minute. I'm closing. There's no agreement that he's in possession. Yes. Para? Interfering with the possession. How is he interfering? He is not in possession from 26/3/2019. And my lord, subject to correction, there is no averment in the plaint, to the best of my reading, that on the date of the plaint, he is in possession and he approached the court to protecting his possession. That is one. Secondly, my lord, what happens to the money? I gave him 160 crore. We entered into a minutes of the meeting. My lord, the learned judge, with great respect, erred in saying, I must refer to a particular clause of the development agreement and amend it. I'm adding a right which the development agreement may or may not have given to make it clear that apart from the rights under the development agreement, I have now a right. If you don't pay the money by such and such a date, I can sell the property. Now kindly see that and I'll end. Kindly see the minutes of the meeting. The minutes of the meeting are at page 430, 433, volume 3.
The learned judge has extracted that in the order itself.
No, my lord, not the. He has. No, I'll only show one clause, my lord. Kindly take volume 3, page 433. Minutes of the meeting, man. I've got spare copies.
No, we have.
No, kindly see, my lord. Statesman House is being redeveloped as a mall by a developer pursuant to a registered agreement dated 26/3. So I refer to the development agreement in the opening line. Then, owner and developer agree as follows. owner has agreed to purchase and acquire the right from 130 plus 30, 160 crore to be paid in the following manner. He didn't pay me a pie. Then over the page, owner has agreed that apart from the aforesaid amount, 160 crore, he has to pay the following debts. Then C, in the event the owner fails or is unable to fulfill its commitment of payment of any of the aforesaid mentioned amount mentioned in clause A or B with interest, developer will automatically entitled to dispose of the project in its entirety for recovery of all its dues at its sole discretion and in any manner whatsoever without any reference to the owner, and the owner consents not to raise any objection whatsoever with regard thereto, and also extend necessary cooperation to the developer in this regard, and in turn the developer will act to the best of its ability. The developer at its sole discretion would be entitled to deal with any manner the entire project to any one or more purchasers or lessees or the like of its choice, and at a consideration to be solely decided by the developer. And further, the developer shall, after retaining all the amounts payable by the owner to the developer, to it as mentioned, etc., till the date thereof, make over the balance. I have a balance of 14 crore. I've tendered to him. I've sent him an email. Your 14 crore is there. Please come and take it. Now, this is not an amendment of the development agreement. This is an amendment in a stricto sensu sense, but it's an enlargement of the rights under the development agreement. This gives me a right. For 1 year, he did not pay me a pie. This is May 2024. I sold him June 25. 1 year and 1 month later, since he did not pay me a pie, and many other claimants are against him, but I'm not. I sympathize with him. Therefore, I had to protect my interest. He found a buyer 1 year ago, but that buyer backed out. I found a buyer, which is Harisala, Harisala, and I paid him. He's paid me good money. I have recovered my 160 crore. I've paid off all the debts, and I've taken my 47%, and his 52% is safe. 14 crore. I'm willing to deposit it in your lordship's court. I'm willing to send it to him. 14 crore. How can he get an injunction against us? He can't get an injunction against us. No, I'm stopping. They're talking to each other. I'm not taking anything more. My lord, if your lordship wants judgment, I can tender 2008 4 SEC 182, followed subsequently 2008.
One second, sir.
2000, one judgment I'll give. 2008, volume 4 SEC 182, paragraph 4, 5, 6, 7 are the statement, and paragraph 10. Undisputedly, the suit was one for possession, permanent injunction, and in such a suit, the plaintiff has to establish that he is in possession in order to be entitled to a decree for permanent injunction. On the date of the plaint, he was not in possession. He parted it with 6 years ago. Below the learned judge, I submit with greatest respect, erred in granting the injunction. It's completely, completion certificate has been obtained. he suppresses the completion certificate. He's been informed about it. Completion certificate has been obtained from the Kolkata Municipal Corporation. He suppresses. Two things he suppresses, letter of possession and the completion certificate. Therefore, I submit, my lord, the interim order may be vacated completely. Obliged.
As of today, I'm holding Mr. Dutt's brief because he is out of town. May I assist your lordship, Lord? Lord, two things have been submitted for your lordship's consideration. May I deal with those directly instead of taking your lordship through the entire sequence of facts, which I will later on. First, Lord, is that the transaction of sale conducted by Merlin in favor of Hatishala was pursuant to a minutes of meeting, or the minutes of meeting, which was minutes of meeting which was held in line with the joint development agreement. The minutes of meeting of 10th of May 2024. And it has been argued that the agreement between the parties, as evidenced by the minutes of meeting, gives Merlin a right to sell the premises. I think this was the argument. This no, the sale takes place in term by the execution is in terms of the power of attorney, but the right to sell arises out of the agreement in the minutes of the meeting.
Power of attorney is, my lord, the sale. My lord, the agreement has not given, my lord, it, in the sense, my lord, that it's open to Merlin to sell, but my lord, it has to be a sale in the name of statesman. My lord, as the holder of the power of attorney, the sale, my lord, has been
that's the modality. Whether I will sign it myself or he will sign it on my behalf. That's the power of attorney issue. I'll come to that later. But the right to sell, it is contended, arises out of the agreement contained in the minutes of the meeting. And in my which is in terms of the joint development agreement. Your lordship has seen the notings of the. It has been noticed by the learned judge that a registered agreement cannot be modified by an unregistered agreement. Clauses not being considered. I'll not come to that immediately, but I'll come to the, in my respectful submission, no more basic point. This minutes of the meeting did not and does not give Merlin the right to sell the property. Your lordship will find nowhere in the minutes of meeting there is any right conferred upon Merlin to sell the property in any situation, whether I pay or I don't pay. And I'll explain to your lordships why immediately. The second argument is that possession has been delivered long back. Now, Lord, everywhere in the plaint, in the letter of possession, in the joint development agreement, all that has been said is that the developer has been put in possession for the purposes of carrying out the development work. Now, Lord, there are judgments galore, including, Lord, by division bench of this honorable court, that in such a situation where the landlord lets in the developer into possession for the purpose of carrying out the development work, while de facto possession may be with the developer because he's working at site, the de jure possession continues with the owner. Lord, I'll come to that judgment, Lord, but I come to the more basic point, Lord, which goes into the root of the transaction between Hatishala and Merlin. Lord, that's the minutes of the meeting. If your lordship please comes to that, Lord.
Mr. Sen, before that,
yes, Lord.
What is your right in that property? The agreement, under the agreement, you had right to 52.5% of the sale proceeds or proceeds of letting out whatever of the property after it was developed. Monday, Mr. Mukherjee, you'll have to rise, different bench.
But I will tell Mr. Dutt that these were your lordship's queries. I understand this issue.
Secondly, purely money claim.
Lord, Lord, here your lordships will find they do not have a right at all. There are pleadings of fraud, but your lordship will be satisfied that Merlin does not have a right at all to sell.
Power of attorney gives the right.
Time fix kore di. Tuesday কিছু time fix করা আছে দেখো আপনি appellate side দেখো. Tuesday you're all available.
I'm, my lord, my learned friend, my lord, now travels all over the world, my lord. I am here.
So you're not available on Tuesday or Wednesday?
Lord, keep it on Monday, Lord, if it's
Tuesday,
Monday or Tuesday you're not there?
Sorry, my lord.
Tuesday.
Monday we have fixed another, two matters we have fixed already on Monday.
Monday
or
is the
Wednesday.
But maybe try our luck on Monday, my lord.
Monday. You say.
Monday or Wednesday.
Lord, let it retain its position. Let it retain its position on Monday.
Monday.
New application, first matter. It will be the first new application then. Lekho, Likhun. We have heard Mr. S.N. Mukherjee, learned senior advocate, representing the appellant in APOT 265 of 2025, 4 or 5 action করবেন বুঝেছেন? Stop. We have also heard Mr. Chidambaram, learned senior counsel, representing the appellant in APOT 268 of 2025. Paragraph. Mr. Sen, learned senior counsel, representing the respondents in both the appeals, begins his submission but does not conclude. Paragraph lists these matters once again on Monday date under the same heading as the first item.
Lord, may I request everybody, Lord, for the sake of convenience, since there are 2 appeals, if we could take the page numbers from the first appeal. That would be convenient if it suits everybody.
I have no objection, but I'll amend my pages.
Very good.
All right.
দেখুন ওপরটা বুঝতে পারছেন তো হাতিশালা ডেভেলপ করছে লেখা
Oh, ঠিক ঠিক
Number 1.
And I am here for the appellants, and I have instructed
Appellate side. The
Appellate.
instruction.
that this matter has become infructuous. Your lordship may pass necessary orders to that effect.
Then we'll just dispose it of recording here.
Only his submission.
Yes. You're for the appellant.
I am for the appellant.
Oh,
According to him, it is
My
infructuous.
is in terms of the order passed by the Honorable Apex Court, this matter has become infructuous.
learned advocate for the appellants লিখছো কেউ? Learned advocate for the appellant submits that in view of a recent order passed by the
Paragraph 8 and 11 would be the relevant paragraphs for your lordship's consideration.
Yes, it seems so. Seems so. That in view of, in view of recent, in view of the judgment and order dated May 3, 2024, passed by the Honorable Apex Court in civil appeal number blank,
7071, my lord.
civil appeal number 7071 of 2020. No, that is the SLP civil number. In SLP, in SLP bracket civil number 7071 of 2024, comma, this appeal has become infructuous. Stop. A copy of the order is produced by learned counsel. Stop. On a perusal of the order, it seems he is right. Paragraph. This appeal is accordingly disposed of.
The MAT number would be 2122 of 2023, Your Lordship. Dr. Ranveer Bose versus College.
Appeal disposed of means मतलब the impugned order remains मतलब because the impugned order has not been touched by the honorable.
Nobody has touched it.
Even there was a delay of 1,000 days. Section 5 was there.
Section 5 has not been allowed in this matter.
I know, man. I'm not saying anything contrary to what Mr. Bonju.
Hey, along with the connected দুখানা application আছে দেখে নিও.
One for Section 5, one for stay application. I'm grateful, man.
Well, Section 5 has not been allowed.
Yes, I say so.
So there is basically no appeal on board without the Section 5 being allowed.
All disposed of.
No, this Section 5 disposal means Your Lordship is continuing the delay also. It will be inconsequential.
Don't be so technical.
Well, it's a hard fought matter. Again, these points will be taken in the next
But
round.
I'm not there. He's there, I'm not there.
My lord.
I'm grateful.
Grateful, Your Lordships.
Item 2.
Item 2 নেই কেউ আছে? Pass over.
Item 3.
My lords, I beg to appear on behalf of the petition in this case. On the last occasion, my lord, before that your lordship issued a rule, my lord,
What
against
is
the
this
petitioner.
matter? Court
But-
on its own motion?
Lordship order dated 3rd March 2025. Lordship, may I submit affidavit?
1 second, let us remind ourselves. 3rd?
3rd March 2025.
Mistake.
Ma'am,
Farm for the state in that matter.
Islam affidavit.
তুমি আর আমি তো করে
ठीक है सर सब चले তারপরে
এখানে ফাইল করেছে যে বেল এটা কমিউনিকেশন
You want to file a response to this affidavit?
if required we'll have to, but I completely lost track of the matter, my lord.
Basically, by suppressing the pendency of the bail application before us, his clients obtained bail from the trial. And here they came and said, we are not pressing. Then the state, you only, I think, Mr. Keshri, you handed up something to us. Yes. Oh, the bail orders granted by the.
That was perhaps the instruction that I received. So I had handed over.
You take a copy of the affidavit, consider if you wish to file a reply, because these matters cannot be encouraged. These things cannot be encouraged.
This is what
So advise us on the next day what we should do. We had issued rule on March 3, 2025, calling upon the petitioner to show cause as to why the bail obtained by him from the learned trial court by suppressing the fact of pendency of the bail application before us, should not be cancelled. Stop. Paragraph. The petitioner files his response to the rule in the form of an affidavit affirmed on March 10, 2025.
এটা তো ফার্স্ট টাইম লাগে আসেনি লাগে এসেছিল কোনদিন এসেছিল
এগুলো কি বেঞ্চে এরপর আরেকটা অর্ডার আছে
Consider. In the form of affidavit affirmed on March 10, 2025, be taken on record. A copy of the affidavit has been made over to Mr. Keshari, learned advocate for the state. Paragraph, we request Mr. Keshari to consider the affidavit and come back on the next date whenever whenever this bench is again available. The state will be at liberty to file its response to the said affidavit of the petitioner. We'll give the date later. We can't give you the. মনে করে করো ছুটির পর এটা করে দিও আবার। Saw you after a long time.
That is why we were.
Since I ceased to be a criminal.
And my lord, we are ceased of going to the courts where your lordship is now sitting. So we don't have matters with your lordship anymore, sir. But whenever at least I get a chance for the petitioners or for the respondents, I appear in all writ matters, everything. So
Good.
whenever I do have an opportunity.
All right. Yeah.
Item 4. So we appear for the petitioner. This is the service of the affidavit service of contempt application.
No order passed till date.
Now till date, Mala, the new incumbent has joined his post.
Oh, then add him.
Okay, add him.
Affidavit of service filed in court today. We kept with the records. It appears that service has been effected on the alleged contemnor. However, learned advocate for the petitioner tells us that there's a new incumbent in the post of the block land and land reforms officer. Paragraph, leave is granted to learned advocate on record for the petitioner to implead the new incumbent in the post of BL and LRO, South 20, Shonarpur block, South 24 Parganas, as the respondent, as the alleged contemnor / respondent number 2. In the contempt petition, the cause title of the contempt petition be amended accordingly. Paragraph, let service of this contempt petition be effected on the added respondent and fresh affidavit of service be filed in court on the next date. Paragraph, list this matter after the puja vacation whenever this bench is again available. Ja, হয়ে গেল তো না একটাই আছে।
Item number 2.
Usual or Abhijit, dismissal.
I'm for the state. Item number 2, I'm for the state.
Yes, you're not for the applicant, no? No. So give your appearance. এই original side নেই তো এই বেঞ্চে চল এটা কি পড়ে আছে এখানে
last copy.
Page number 1.
Maybe you're right. But I'm the petitioner. Person will lost the direction. Earlier direction. A copy of the content was sent upon the contender. As contempt. I do not know whether he is still Dibyendu.
Yes, whether he's still the special land acquisition officer.
Special land, Dibyendu Goswami.
No, you have to find out. If he is not, then you have to add the new incumbent.
No, I don't know because nobody said. I do not know. My client's son has come here, but don't know. Most probably he is holding that post.
It is your problem, Mr.
Oh, yes.
So what do we can issue a rule?
Yes.
Affidavit.
Oh, I'm sorry, I'm extremely sorry, I tender my apology.
Mr. Tapush Bhattacharjee, you're such a senior counsel.
Well, yes, there's a mistake. I told my
File one in course of the day.
Yes.
File another copy.
Yes.
পেয়েছে দেখো
দিয়ে দেবেন ব্যাক করে দেবেন আমাকে দিয়ে দেবেন আমি তৈরি করব
ডেলিভার তো First, affidavit of service filed in court today. We kept it the records. Stop. It appears that the alleged contemptor has received notice of this contempt application. Paragraph. Nobody appears for the alleged contemptor. Stop. It seems that the alleged contemptor has taken court proceedings very lightly and casually. Stop. Paragraph. There will be a rule as prayed for. Stop. The rule is made returnable 2 weeks after the puja vacation. When puja vacation, stop. Paragraph, the petitioner shall put in special messenger cost by next Budhwar date the other.
24th, I think.
Yes.
24th.
By September 24th to expedite service of the rule on the alleged contemptor. Paragraph, list this matter after 2 weeks after the puja vacation, whenever this bench is again available.
Yes, right. In course of day, I shall file another appeal of service.
Yes. If we don't find that on record on the next day.
No, yellow city. As a comply, I don't know, my lord. Some division bench, but only the habit, my lord.
I saw you on the road. I think when I was coming to this building, you were standing.
Yes. I was going to.
I waved at you.
Yes.
You did not wave back.
I forgot because I was searching it. But Ola Uber, I am going to land tribunal. That's another matter. Sorry.
They will literally the 2 weeks after.
Sorry. I get to learn.
Lordship, I'm filing the affidavit of service.
Yes.
Lordship, this is that matter. Lordship, if your Lordship kindly comes to the order dated 4th of January 2023 passed by this by your Lordships. Lordship, this is where the CDPO had practically had behaved as if it was the appeal court, Lordship. Your Lordships have taken note of that. Your Lordship kindly goes to the order dated 4th of December 2023. Lordships have found it.
Are you sure Sujoy Banerjee is still the CDPO?
Yes, I have that. But Lordship, what has happened, Lordship, after this order was passed, they have allowed me to join from the 1st of January 2024. I am working, I am getting paid, but I have not been given an appointment letter.
In this contempt,
I understand, Lordship, but
so do you wish to press? You are for the alleged contempt?
They have put the annex 1 documents at page 32 where the decision has been taken by the CDPO law, my lord.
That is on 29th of August.
You better
2020.
file an affidavit. File an affidavit.
That is the cause of contempt, the decision of the CDO, GPDO.
File an affidavit.
Let it
Since you are appearing, affidavit of service filed in court today be kept with the records. Stop. Learned counsel appears for the alleged contemnor. Stop. Paragraph. Let affidavit in opposition to the contempt application be filed within 2 weeks after the puja vacation. Stop. Reply thereto, comma, if any, comma, be filed within a week thereafter.
Ask your lordship, because your lordships had constituted a bench on 2
You
weeks.
tell us
after.
when,
So
what,
if
within
it
what
would come
time?
in with,
How much time you will take to file reply? Tell us.
I would
Within a
take
week
my
thereafter.
lordship,
Stop.
there's
Paragraph. List this matter after 3 weeks. 3 weeks after the puja vacation, whenever this bench is again available. আর কৌশিক শোনো, এই দুটো ম্যাটারই তুমি একসঙ্গে দিয়ে দাও, তাহলে সপ্তাহ 3 বাদে একটা বেঞ্চ করে দাও আমাদের, করে দিয়ে দাও।
it's taken 2 years for the bench, lordship.
Thank you.
Deeply obliged, lordship. ঠিক আছে।